Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to give their attention, where the court is now sitting. God save the United States and this honorable court.
We will hear argument first this morning in case 2255, Mahanoy Area School District versus BL. Ms. Blatt?
Thank you, Mr. Chief Justice, and may it please the court. Tinker should apply off-campus for 3 reasons. First, such speech can cause on-campus disruption. Second, respondents' approach would create chaos. And third, a school nexus requirement and Tinker's substantial disruption test guard against abuse. First, off-campus speech, particularly on social media, can be disruptive. The internet's ubiquity, instantaneous and mass dissemination, and potential permanence make the speaker's location irrelevant, yet the decision below arbitrarily treats location as dispositive. Second, respondents concede schools can address off-campus speech, but they propose an administrative nightmare where the sheer complexity heightens the risk of calamitous error. First, a 7-part test would define the school environment. Second, then one would check if the off-campus speech fits within 5 separate First Amendment doctrines that have never been defined in the school context. Tinker would mystifyingly toggle in and out of coverage as kids move about today. This court should not substitute the 20-year status quo of applying Tinker off campus. Third, schools cannot target political and religious speech. Tinker applies off campus only when the student targets both a school audience and a school topic. And more broadly, this court can clarify Tinker's reach both on and off campus. It is irrelevant that critical or unpopular speech is the but-for cause of substantial disruption. The speech itself must be culpable. It must inherently compromise school functions, like organizing walkouts. Or the speech must objectively interfere with the rights of others, like severe bullying. But if listeners riot because they find speech offensive, schools should punish the rioters, not the speaker. In other words, the hecklers don't get the veto. School special needs are limited to teaching kids how to think, not what to think. I welcome your questions.
Counsel, you said that the schools can't regulate political or religious speech, but also that the schools can regulate speech from off campus that is directed at the school. So what do you do with political or religious speech that is directed at the school? You know, a sign a student is carrying around off campus that says don't approve the school bond funding referendum. How do you balance the one situation against the other?
Well, that speech would not come within the school's regulation even remotely because it would fail both Nexus and Tinker. It fails the Nexus case because it's not directed to a school audience, that's the public, and it has nothing to do with a particular school. It's just not a school topic. So under our approach, and I think this is the government's approach too, it's identical. You go to 2 steps, either of which is easier for a court to handle in terms of protecting free speech. One, make sure the audience is the school and the topic has to be about the school. And if it's easier, go ahead and jump to Tinker and say that no matter how much offense someone takes to that speech, that's not a substantial disruption just because listeners are offended.
Well, let's say that the protest is don't approve the school referendum because this school is awful, or because Ms. Johnson is teaching at the school. And it's put out by somebody on there as a Snapchat, so it certainly reaches the school audience. Political speech that's directed at the school.
Yeah, so you can have, that would be a school audience, and it's Ms. Johnson is a school topic, so it's a nexus test. And the reason why that could never satisfy Tinker, and that is because if it's just the listener's reaction, speech that's critical, even ridicule of a school, schools cannot punish it because of their offense or their reaction to it. They could punish the manner. So in other words, if a female student wants to say, Mr. Jones keeps calling on boys, that's fine. She can text about it. She can social media about it. She can't pick at the teacher's house or stand up in class and say it because that inherently interferes with the school's ability to teach. But she's entitled to her views and to express them.
Thank you, Counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Ms. Blatt, how do you separate that? What if a student said some of those same things that the Chief Justice posited, but in a social studies class? How would you separate that from just participating in class, or as opposed to doing the exact same thing or saying the exact same thing off campus?
Yeah, so Tinker, again, assuming it fits the nexus test, Tinker is always going to be context specific, and whether teachers or school officials can forecast a reasonable disruption depends on when and where the student speaks, how many people hear it, and what the student said. And when and where in the classroom is going to be very different as opposed to a sleepover. But now when it's on social media to 200 people or even 1,000 people, there's no question that the effect might be different. But in your case, if you want to say, Ms. Johnson, you're a terrible teacher, she should do that in office hours or on social media, not in the middle of class. That's disruptive. Can't do that. That interferes with the instruction of the classroom.
So you did say, you mentioned context, and you said that, well, the sleepover is different from school, or you suggested that. And then you did mention social media, but aren't we at a point where if it's on social media, where you post it on social media doesn't really matter? You could do it in class, algebra class, or you could do it at a sleepover and say the exact same thing about Mrs. Johnson. So how would that make any difference where you post it?
Well, that's precisely correct. When it comes to the internet, things like time and geography are meaningless, and it makes absolutely no sense whatsoever to say that the same speech is somehow within the school's regulation if it's 1 foot on campus or 1 foot off campus or at the Starbucks or at the CVS or in your car or on the school bus. The internet is ubiquitous. It doesn't have a geography.
So why does it have to be about the school? Can't there be comments about other hot-button issues or about current controversies like protests or Black Lives Matter, Antifa, or Proud Boys or something like that? People can take sides that are just as disruptive in the school setting as comments about Mrs. Johnson.
The difference is from Tinker itself. Schools are not in the business of teaching kids what to think, Justice Thomas. You're entitled to think whatever you want about Israel or race or Black Lives Matter. Now, it's a different thing if you take something that's political speech, like the Confederate flag alone. It communicates nothing. But if you take that speech and terrorize a black student with it, then the message is, I don't want you here at the school because you're black. That's very different than just the Confederate flag standing alone. I don't know what that communicates. I need to know more about context. But it's inconceivable that talking about a wide variety of religious or political speech, unless you take it in a way that uses that as a weapon to terrorize a particular student or teacher, it is off limits. It has been off limits since 1969. And the other side is just wrong to suggest that schools somehow are the gulag on campus. That has never been the rule since Tinker. And in 2001...
Justice Breyer?
Good morning. I read Tinker, and Tinker seems to say that in the context of a student protest, in school at least, school, you cannot punish this unless there is material and substantial disruption, or you invade the rights of other students. You cannot. It doesn't say if it does those things you can punish it. It says you can't unless. And the issue here seems, does that apply off campus? Well, why not? After all, if I look at the case here in the record, is there in the record something that shows that what this young woman did? I mean, she used swear words, unattractive swear words off campus. Yeah. Did that cause a material and substantial disruption? I don't see much evidence it did. And if swearing off campus did, I mean, my goodness, every school in the country would be doing nothing but punishing. And it certainly didn't help others. I mean, disrupt others. It didn't hurt others as far as I'm aware, as far as I could see in the record. So why isn't that the case? I mean, sure, if you exceed Tinker, unless you meet Tinker, you can't punish it, at least in the context of protest. And here, pretty clearly, it didn't satisfy what Tinker says is necessary to satisfy.
So I think it's fair to have the approach that the concurring judge did below, which is I don't really need to talk about any of this because the school failed Tinker, but the Third Circuit said it was dispositive. It didn't matter what she said. She could have done this to 1,000 people every night of the season.
All right, you want to review the Third Circuit. That's what's mystifying me. The Third Circuit says Tinker doesn't apply. If Tinker doesn't apply, they can punish more, not less, because Tinker puts some limits on what you can punish in school. You'd think a fortiori outside of school.
So what is mystifying about the Third Circuit and the other side's brief is that we think Tinker faithfully applied, and this court has not had a Tinker decision since Tinker. So I think it would be helpful to explain that substantial disruption can't be a direct but-for causation. But more to your point, they say schools can do whatever they want under 5 separate doctrines. They say, look at strict scrutiny. Bullying, I don't know what they say. Extracurricular, I don't know what they say either. Maybe there's a conduct exception. And also threats, but let's adapt all of this for the kid environment. Tinker has been a familiar test for 51 years. And it is, in this case, I don't think it's that difficult. The question is here, she targeted her coaches, the sport, and another teammate's ability to play, and the coach reasonably forecasted someone who berates with a profane gesture and a word. All 3 of those things is not somebody you'd want at the bottom of the pyramid. And the record was not just the swearing, but it was disrespect for the coaches and the entire team and her teammates in connection with the swearing.
Justice Alito?
Ms. Blatt, I understand you to say that schools cannot discipline a student for things that the student says outside the school, not in connection with a school program about subjects such as politics, religion, morality, economics, et cetera, et cetera. The problem is when the student says something that implicates those subjects but links it in some way to a student or a teacher. And what you say is, and the Solicitor General makes a similar argument, it matters whether the speech targets the school. I have no idea what it means to target the school. Well, let me give you an example to make this more concrete. And since Tinker occurred back during the Vietnam War, it will relate to that. So during the war, a student says, the war is immoral, American soldiers are baby killers. I hope there are a lot of casualties so that people will rise up. Even if that would cause a disruption in the school, I understand you to say the school couldn't do anything about it. Is that right?
That's correct. That would be a heckler's veto, no can do.
All right. So now the student says exactly the same thing, and he adds, quote, our classmate Johnny Jones' brother is one of those blankety-blank baby killers. Can the school do something about that?
So that would turn not on, obviously, where, if it's on the internet, the location. It turns on, I think, what the Third Circuit originally said in Sachs. Obviously, it was a decision by you that says there has to be a line drawn between somebody taking offense and an actual objective interference with their ability to educate. I'm not sure your example would, but that's what schools have to face every day. When you insult someone, okay, that was not nice, your feelings are hurt, we need to have a conversation.
Yeah, well, see, that's where that is where I think there is a problem, because when you tell me that or you, one of the other very able attorneys, says it's context specific, it depends on the facts of the particular case, there are a lot of things you have to consider. I'm really worried about how that is going to be implemented. I think if schools are going to have any authority under Tinker outside of school, there has to be a clear rule. That's what I'm looking for.
Sure. The clear rule has been, I think, under the law or policies in all 50 states, and it's certainly in written statutory law in 26 states, that the standard for bullying is severe, persistent, harassment that interferes, actually prevents that child from getting an education. So being offended is irrelevant. You have to basically, it has to be very severe and persistent.
Well, I just don't understand what that means in concrete terms. I'll give you another example. My time is basically up. A student believes that someone who is biologically male is a male, and there's a student who is biologically male but identifies as a woman, has adopted a female name, but the student who has the objection refers to this person by the person's prior male name and uses male pronouns. Can the school do something about that?
I think with something like a name, a school could say, well, listen, we're going to have, everybody is going to be called by the name we have on the school records as a matter of decorum. We're going to do that. And if they want, they can just accommodate the person by saying, why don't you just call him, her, Johnny, or whatever the name is, and just use that and say Johnny's book. I think you just accommodate. But to answer your question about being, that's why Tinker's been around for 51 years. The federal government has like 10 federal agencies that deal with this. Schools have to deal with this every day. They try not to make mistakes while keeping kids from killing themselves because they're bullied.
All right, thank you. My time is up.
Justice Sotomayor?
Ms. Blatt, the problem that I have with Tinker is that I'm not sure it's any clearer a rule than any of the others that you're criticizing. Let me start with just this case. Can you punish the student for cursing at home? Absolutely. Or at her parents? At home?
Absolutely not, nor could you do that.
Can you punish her for cursing in her conversations as she walks to school?
Absolutely not, although under respondent's test, I guess you can. But absolutely not.
All right. Now, if you can't punish them for doing that, you're punishing her here because she went on the internet and cursed and used a curse word related to what? To her unhappiness with the school and cheering, right?
Yes, she berated her coaches, the sport, and other teammates.
Well, we could quibble with that, but my point is, I'm told by my law clerks that among certain populations, a certain large percentage of the population, how much you curse is a badge of honor. That would surprise many parents. However, if it is true, where do we draw the line with respect to it targeting a school? Kids basically talk to their classmates. Most of their conversation is about school. Most of their exchanges have to do with their perceptions of the authoritarian nature, their teachers and others. And why isn't this any different than just that the coach of this team took personal offense?
So all those
she spent a few minutes talking to students, reporting this incident. How is that a substantial disruption, number one? And how is this, the nature of this speech, such that it intends to provoke disrespect when she put it to a page that was supposed to disappear, and it was only a classmate taking a snapshot who showed it to anybody?
Yeah, well, Justice Sotomayor, I'm not impressed with the Snapchat defense, because she could do the same thing to 1,000 people and say, oops, it disappeared, and I'm going to do this every night to my coaches. They don't like it. It's disrespectful. My teammates are afraid of me. I don't really care. And the answer is because she's a cheerleader, and it's an extracurricular program where she consented to an extra degree of regulation because she's a school ambassador. It's a self-contained program that teaches not just teamwork, but respect for coaches.
Counsel, I note that the school's ban on cursing is only during the school year, and you did not rely, or your teacher did not rely on that prohibition of cursing in its punishment of her.
Right. These are all fair points in what was argued in the district court. I will say the district court said it was pretty much fatal to Tinker that she said it off campus. And with all respect, that is a silly, arbitrary, unfounded, has no basis in any common sense. it would be, all of a sudden it mattered if she had sent it from the school parking lot, and all of a sudden the school could look at it and apply Tinker, and we would be having the same conversation in a Supreme Court case. But the fact she sent it at the Cocoa Hut shouldn't matter into the analysis.
Justice Kagan?
Ms. Blatt, it seems to me that your argument that Tinker is the entire analysis may depend on a version of Tinker that the lower courts really have not adopted. Because you say that there can't be any regulation of political or regulation of religious speech, but I'll just give you two cases. One where there was a ban on shirts saying "we are not criminals" to protest an immigration bill. Another, a shirt saying homosexuality is a sin. And in both cases, the court said Tinker allows the school to say that you shouldn't wear those kinds of things to school. Do you think that's clearly wrong?
It's not. I thought I'll defer to you. I thought that homosexuality as a sin was fine. The border shirt or the "we are not criminals" was a fight where there was basically a match that was supposed to go off, and when dueling factions are wearing dueling shirts, where gang fights or fights are about to break out, and there was a big dissent and concurrence.
Yeah, so I guess that's what I'm asking about, Ms. Blatt, because I would have thought, I mean, maybe I did get that holding wrong, but I would have thought where students say we're going to come in with the Confederate flag, or we're going to come in with, Black Lives Matter, or homosexuality is a sin, or gay pride, in ways that the school thinks is going to cause disruption, that the school can ban those, if the school is right about that, where those symbols or speech will cause severe disruption, that the school can say, no, you can't bring your Confederate flag to school tomorrow.
So, no, I think the actual opposite is true. If you look at the school handbook that we cite, and the New York school handbook says the same thing, the leading case on this is Katie versus Fillmore. It is a brilliant case where the T-shirt was abortion is homicide. Teachers, kids having abortions were upset. They said it was false because abortion is actually legal, and the school said, get over it. He's passively wearing the shirt. He's not terrorizing kids with it. He's going about his day. Leave him alone. And that case is cited as the gospel case for heckler's veto. Now,
so you're saying, Ms. Blatt, that what we should do in this case is just make courts clear, tell courts, look, Tinker is it. It's it on campus. It's it off campus. But in applying Tinker, you have to allow religious and political speech, no matter how disruptive the school, it will be in the school.
Unless, as that Sachs opinion says, and as all of the Confederate flags say, when it is used in context to terrorize a student.
A particular student, right, but it can't just be we're all bringing our Confederate flags to school and it's going to cause a riot.
So if there are gang riots, and yes, those cases are all dealing with the Confederate flag is being brought with the backdrop of race riots. There is no question that is like a fighting word in context, and fighting words aren't protected.
Well, now I don't know what you're saying, Ms. Blatt, because first you said a school can't prohibit Confederate flags, even if they're going to be disruptive, and now you say they can.
So the difference is, when we talk about disruptive, it's a misnomer. You cannot ban T-shirts and symbols because people are offended or they threaten to riot. Now, you can, in context, if you have a very extreme situation where really the facts are a new black kid arrived at school and they raised the Confederate flag.
Okay, thank you, Ms. Blatt.
Justice Gorsuch?
Yeah, I'd like to pick up where Justice Kagan left off. I'm confused. You started off this presentation by saying political and religious speech are absolutely protected. But I think in response to both the Chief Justice and Justice Kagan, you've suggested that there may be limits there as well. Can you explain what your test is?
Yeah, the only limit is where, that I've seen in any of the case law, is where there are race riots and gang fights and student walkouts. You have very disruptive, volatile environment in the school. So none of this applies to anything to do with the question presented. But
so it is a major disruption test with respect to political and religious speech as well?
It is a major disruption test that takes out the word just because students are offended and feelings are hurt and you're very angry about the speech. Feelings are hurt.
No, I understand offense isn't enough, but if there's a major disruption, that is enough.
It's a major disruption with reasonable. Just because kids say, Miss So-and-so, we're gonna riot if that kid walks in with a Confederate flag, then you suspend the kids who threatened the riot. You don't suspend the kid with the Confederate flag.
Sure, but if the school thinks that that the kids are reasonably reacting to offensive political or religious speech, then it can address that issue.
I would say not offensive. I would use the word terrorizing.
Terrorizing.
And offensive.
Okay.
Terrorizing.
Terrorizing.
Really,
all right.
Yeah, it's not.
And then does it make a difference that this case involved an extracurricular activity?
Yes, with respect to the application of Tinker, because of what I said about the goals, and you can offend and destroy the program without affecting the school at large. So here, the student was not in any way, there was no disciplinary action taken with respect to the school. She was suspended from the cheer team, and I think under the other side's view, she couldn't have even been asked to write an apology or suspended for one game. And she could do this every night. As long as she waited till the Cocoa Hut to do it, she could berate her coaches all day long. And I think that that's very different. If students want to use swear words, even on the internet, that's fine. And they can do it with respect to teachers, too. It's going to have to rise to the level of harassment.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice, and good morning, Ms. Blatt. I want to focus on the facts of this case a bit and my reaction to it. As you say, and I think helpful for you, the context here is a team and a coach, not the school more generally. But as a judge and maybe as a coach and a parent too, it seems like maybe a bit of a overreaction by the coach. So my reaction when I read this, she's competitive. She cares. She blew off steam like millions of other kids have when they're disappointed about being cut from the high school team or not being in the starting lineup or not making all-league. And just by way of comparison and to show how much it means to people, arguably the greatest basketball player of all time is inducted into the Hall of Fame in 2009 and gives a speech. And what does he talk about? He talks about getting cut as a sophomore from the varsity team. And he wasn't joking. He was critical 30 years later. It still bothered him. And I think that's just emblematic of how much it means to kids to make a high school team. It is so important to their lives, and coaches sweat the cuts, and it guts coaches to have to cut a kid who's on the bubble, and good coaches understand the importance and they understand the emotions. So maybe what bothers me when I read all this is that it didn't seem like the punishment was tailored to the offense, given what I just said about how important it is and you know how much it means to the kids. I mean, a year suspension from the team just seems excessive to me. But how does that fit into the First Amendment doctrine, or does it fit in at all in a case like this?
Well, I don't think it does, because it's analytically distinct whether the coach could act at all versus due process considerations about the extent of the punishment. And I think the rule, and also this is the remand point. The district lost on this issue, and the Third Circuit did not go on this rationale because there was evidence of the team cohesion. But I think, whether I understand that Michael Jordan was upset, but at some point, presumably, he was respectful to his coaches. And there's a line that coaches always have to know their team and know what works. They have to act in the best interest of all teammates, team participants. And one of the things you learn
in the moment, you know that kid's going to be upset, and you recognize that. I'm not saying this is justified necessarily. I'm not, but a year seems like a lot.
Well, again, then you're going to be in the business of.
I agree. That's the problem. I agree. On the legal issue, the do no harm, I think legally speaking, we should try to do no harm here. Your approach would be to just say the Tinker standard applies regardless of the precise location of the speech and just remand. Is that enough?
That's absolutely enough.
Thank
yes,
you.
and I think, yes.
Justice Barrett?
Good morning, Ms. Blatt. So let's assume that I think about the case in the following way. You know, that high school students enjoy the same free speech rights as everyone else. Tinker acknowledged that in the context of this, once you cross the schoolhouse gate, those rights are somewhat reduced because of the school environment and the need to, you know, control and avoid substantial disruption, but they're not lost altogether. But that nothing in Tinker suggests itself that it applies outside of the school environment. And so what you're asking us to do is to extend the school's authority that Tinker acknowledges outside of the school environment. And I think you have good policy reasons for doing that. You know, I think harassment, bullying, and I think threats of violence against the school and cheating are all things that would be of concern. I don't see a lot of doctrinal support for saying that Tinker applies, you know, that the school's increased authority applies. Tell me what you think doctrinally your best authority is.
Sure. The 100 years of case law that was unambiguous that schools could regulate anything off campus.
Well, let's assume I don't think there's, I think I read the history a little bit differently. What about in our precedent? Do you see anything in our precedent that really requires this extension of Tinker?
Well, all the school speech cases, there's only 4 of them, are tailored to the school interest at stake. And so the question is, in terms of what need to protect the school. And if we're talking about a narrow category of speech that actually, and what here is threatening the extracurricular program, so that doesn't fall into your cheating or bullying. It is speech that destroys the morality of team cohesion.
Well, but I think actually, Ms. Blatt, that's part of the problem because, you know, you point out that the other side's test or proposed test has its problems at the edges because of the internet and remote learning and all of that. But your 3-part test certainly has its own issues. You know, it's not going to be easy to apply. And I think a lot of the questions that you've gotten today show a concern, including in this case, that schools abuse this authority and that they punish things that maybe don't cause substantial disruption or political speech or religious speech that they shouldn't. Or, you know, I think you've heard a lot of skepticism about whether the speech at issue in this case actually caused substantial disruption. So I guess my concern is if we have two tests being offered or on offer, neither one is going to be easy to apply in all cases. They'll both have hard cases. Which one ought we apply? Which one is the more protective of speech? And let me ask you this, insofar as the policy concerns go, nothing in the First Amendment prohibits soft discipline, right? Like in this case, the cheerleader coming to school and being told, rather than being kicked off the team and punished, being told, we're aware of this Snapchat. This is not good for team cohesion. This is not respectful of your coaches. If we see any of this kind of behavior on the field or at practice or undermining morale, there's going to be a consequence, but not imposing one yet. That would be okay, right?
Yes, but there are cases where the student was asked to apologize and the student sued the coach and the school and said, I don't have to say I'm sorry. I have a First Amendment right not to say I'm sorry.
Okay, my time is up. Thanks.
A minute to wrap up, Ms. Blatt.
And I think this goes to Justice Barrett's question. Your choice is between the familiar Tinker standard that has applied to social media over the last 20 years. Respondents are going to regulate off-campus speech, but they send schools into completely uncharted waters by replacing Tinker with a Frankenstein's monster of First Amendment doctrines all matched together. Respondents worry about schools suppressing too much speech, but telling schools they can regulate undefined categories of harassment, bullying, and speech inciting violations of school rules invites more suppression. Vague, unfamiliar rules don't work when student welfare is on the line. All this court needs to hold is that Tinker is not subject to a territorial switch. Under respondents' view, it would not have mattered had BL derided her team and coaches every night throughout the season on 12 different social media platforms. Students shouldn't be able to place their speech off limits just by stepping off campus.
Thank you, counsel. Mr. Stewart?
Thank you, Mr. Chief Justice, and may it please the court. Under the Third Circuit's approach, BL could send out snaps from her home every evening disparaging the coaches, her teammates, and the enterprise of cheerleading. Such messages from a member of the squad would have an evident tendency to disrupt the functioning of a school program that depends on and is intended to instill values of team building and mutual support. In situations like these, school officials should be able to intervene to protect the interests of other team members. The Third Circuit's rigid geographic approach is particularly unsound in the context of online speech. since there is no meaningful causal link between the place from which an online communication is sent and the likelihood that it will disrupt school operations. I welcome the court's questions.
Mr. Stewart, if you get to the point of considering whether speech is directed at a school, I wonder how you parse that, because you know, teenagers, maybe most of their friends are also their classmates, and does that mean that anything that they generally send out directed at their friends has to be considered that it's directed at the school?
I mean, first we would say no, even for purposes of the first prong of our test, which is it school speech? But the second thing we would emphasize is that even if speech is determined to be school speech in the sense that it focuses on the school as such, that doesn't mean that the school can regulate it. That just simply means that the school should have the opportunity to make the showing that the speech is likely to cause substantial disruption of school operations.
What about speech, political speech that involves the school? You know, opposing a school referendum because Ms. Jones is a terrible teacher. Do you categorize that as political speech, which is off limits, or speech directed at the school, which can be regulated?
I mean, it's a little bit of both. The part that says we oppose the school referendum is very similar to the speech that was at issue in Pickering, the seminal case about the rights of public employees, and the court said in that case, because there was no close working relationship between the teacher and the school board, there was no likelihood that this would disrupt workplace operations. The part that says Ms. Jones is a terrible teacher, that might take it over the line into school speech, but a single statement like that wouldn't, in our view, have the capacity to disrupt school operations. If there was a continuing, ongoing online campaign of virtual harassment or intense disparaging of Mrs. Jones or Ms. Jones, that might be a different situation, but a single negative comment wouldn't qualify.
Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Stewart, should we analyze the rules of a team, as Justice Kavanaugh alluded to, as opposed to the general rules that apply to the school population? Is there a difference in how we should treat team members versus just students?
Yes, I think there is. And if I could say something about what a comment that Justice Kavanaugh made in the first part of the argument, I think there is in some sense an intuition that people have that the punishment didn't fit the crime in the sense that the suspension was very severe. But there's another sense in which the punishment did fit the crime. That is, BL was suspended from the cheerleading squad, not from school. If the school had suspended her from school, that would have sent the message that this was considered to be unacceptable speech from any student, and that would have been a very difficult showing to make. But the sanction that was actually imposed sent the message that this was unacceptable speech from a member of the team. And I think it's not limited to the school setting or the team setting, that people who participate in projects or organizations that have as part of their raison d'etre cooperation, team spirit, mutual support, they may have to accept limitations on their speech that couldn't be imposed on the workplace generally. For example, if I...
Well, let me squeeze in one other question real quick. When we talk about material disruption as a basis for preventing or disciplining students who engage in certain speeches or conduct, can you also localize that to the team so that if a team member disrupts the team, that it's okay to discipline that team member, even though you wouldn't normally discipline that person as a member of the student body?
Yes, absolutely. And I think it would be impossible to run sports teams at public high schools, or for that matter, public universities, if that were not the case. It happens all the time that cheerleaders or student athletes will do things that disrupt the operations of the team but don't have any larger effect on the school as a whole. And at least so long as the discipline is limited to exclusion from the team or suspension from the team, that's not a problem.
Thank you.
Justice Breyer?
As far as I can see, I can't write a treatise on the First Amendment in this case. And so at the moment, I'm thinking there are only two ways of dealing with it. One, treat it as an example. We can't go beyond that. Look at the record and then decide. Or the other is everyone seems to want some rule, and the rule, I think, might be take Tinker as if it said, which it doesn't, as if it said, school, you do have some authority where there's a substantial injury to disruption in the class, or somebody's going to be hurt in that school, etc. And I would add, but remember, it's outside the school, and that's primarily the domain of the parents. And even when it's inside the school, you're not a schoolmaster. Judge, be careful. Okay, I could say something like that. Well, what should I do?
I think the three or four things I would say are, first, no per se rule that off-campus speech is categorically exempt from school regulation. Second, with respect to online speech in particular, the location from which the post is sent is more or less irrelevant to the likelihood that it would cause disruption. Third, a school can permissibly conclude, as in the teen context, that particular speech will disrupt the operations of a particular school program, even if it doesn't disrupt the operations of the school as a whole. And fourth, in determining what counts as substantial disruption, we should look to the purposes of the program. And here, the coach testified at JA 32 that part of the purpose of cheerleading was to teach team building skills that students would take with them to later life. Team cohesion was not simply a means to some other end. It was one of the objectives of the program. And as I say, reasonable people could differ about whether this isolated snap would likely have the effect of disrupting team chemistry. But the Third Circuit's analytical approach would apply equally in a situation where BL had sent repeated snaps disparaging the coach, disparaging the team, where absolutely the predictable effect would be a breakdown in team morale.
Justice Alito?
Suppose a student says something outside of school that relates to an important subject like politics, religion, morality, et cetera, makes no reference to the school or to a teacher or a student, but the remarks are so offensive that they will predictably cause controversy within the school and could distract the students from the educational process. Does the school have any authority to discipline the student?
No, not on our view. And indeed, the purpose in our analytic test of having a school speech prong is simply to provide a safe harbor, to make clear that in the situation you posit, where the speech off campus has no inherent connection to the school, the justification for regulation that people will be upset when the school day starts, that's simply an illegitimate justification.
All right, so an important part of the test that you propose is whether the speech intentionally targets specific individuals or groups in the school community. The verb target means select as an object of attention or attack. So does school target an individual, a student, or a teacher whenever it refers to the teacher or student?
No, I don't think that's the case. And this is a contextual approach where you would look at the speech as a whole and ask, is this predominantly a comment about an individual, a student, or is it predominantly a comment about a social issue? But the other thing I would stress is, even if in a particular instance you get past the screen and say, this is school speech, that doesn't get the school home. The school.
Well, what troubles me is that what you've just proposed is a very nebulous line, and I'm quite concerned about the effect of this on freedom of speech. I think we need clear lines. Can you clarify? Can you give me anything firmer than what you just said?
I guess the two things I would say are, first, even in cases where we are applying Tinker, you should not just look to kind of the likelihood that disruption will result. You should employ concepts like proximate cause to determine, if a disruption does result, can that properly be attributed to the speaker, or is it the fault of the listener? The thing I would say is the Tinker framework in some respects will apply quite differently in the schools.
Justice Sotomayor?
Mr. Stewart, your test speaks about, I'm not sure, and I'm following Justice Thomas's questioning, seems to focus on sports teams. But one could say that about any extracurricular activity, that there is team spirit of some sort involved in science lab work, in after-school science lab work, in forensic speech writing or arguing. There isn't an after-school activity where the spirit of that activity couldn't be perceived as being impacted by what people find is unpopular. So let's get to Black Lives Matter T-shirt. How about or the Confederate flag? How about if students in any after-school activity want to wear those T-shirts? When would you say that the school could ban that?
I would say not at all, at least not on the team building concept.
But why?
That is, I think that's simply a case in which the free speech rights of the students would be paramount. That is, it is possible in theory to imagine a team in which almost all the members support a particular political candidate, and to some degree the presence of a teammate who supports the opposing political candidate is going to be a source of argumentation, but that doesn't strike at the core of what the team is about. What strikes at the core of the team is...
Do you agree with Ms. Blatt, if there is race tensions, any other kind of tensions on the team, that the school could intervene at a certain point?
Yes, I mean, it certainly could be the case that if people were kind of operating in close quarters and this pattern of tension was established, that might justify some form of speech regulation that wouldn't otherwise be justified. I think the Seventh Circuit in Zemesnik, a case cited in the reply brief for the petitioner, has referred to this as kind of a species of fighting words analysis. And the idea is, even in the adult context, though we don't usually look at the reaction of the speaker, there are some forms of speech that seem intentionally provocative.
Justice Kagan?
Mr. Stewart, is the speech in this case school speech?
It is close to the line because it mentions school and it mentions cheer, but it also mentions softball, that was not a school.
So which side of the line does it fall on?
I think it probably falls on the school speech line, but it's not entirely determined.
So that means really everything that mentions a school at all is school speech, right? Because this is pretty generic.
Well, it's not just the content that we're looking at. The speech, the snap was sent to a wide audience. It included a number of students, a number of cheerleaders. It predictably reached the cheerleading team and the coaches. And again, the fact that there may be some indeterminacy about the first prong of the test doesn't get the school over the hump. The school may still be unable to establish on remand, if the case is remanded, that this speech would have a natural tendency to disrupt team chemistry.
Can I give you a few hypotheticals, and you just tell me school speech or not school speech, and let's just assume that all of these cause substantial disruption, okay? A student emails his classmates the answer to the geometry homework every day after school.
School speech.
Student emails his classmates that they should all skip school tomorrow for an impromptu senior skip day.
School speech.
Student emails that they should refuse to do any work for English class until the teacher changes the syllabus to include more authors of color.
School speech.
So that can be punishable.
If it causes substantial disruption.
Okay. Student tweets that there's pervasive homophobia at his school and that prospective gay students should stay away.
That seems like school speech, especially the last part of it, when it encourages other people to avoid the school based on this characteristic.
Last one. Student tweets that his school really stinks and students should stay away.
I think it's still school speech. It's an assessment of the school as a whole. And as I was saying earlier, the principal point of our school speech prong is to provide a safe harbor for situations where a student engages in very inflammatory off-campus speech that has no inherent connection to the school. And we want to say that the school simply can't try to make the case that that speech should be regulated because of the spillover effects it would have when school reconvenes.
Thank you, Mr. Stewart.
Justice Gorsuch?
Mr. Stewart, is there anything that the petitioner argued that you disagree with this morning? And can you explain, if to the extent there is, any daylight between your test and theirs?
I don't see any daylight. The only thing I would emphasize that I don't think is inconsistent with the petitioner's presentation is that in the context of on-campus speech, the courts have applied a concept of quasi-fighting words, where taking into account the relative immaturity of the school audience and the fact that students are a captive audience, the courts have allowed school authorities to crack down on a narrow range of speech that couldn't be punished outside the school, but is particularly likely to cause a disturbance in the school environment. But with that small caveat, I would agree with petitioner's argument that, in general, disagreement, even strong disagreement by the rest of the students with even on-campus speech is not a basis for regulation.
And then if you could just address more broadly the thrust of the argument from the other side, which is that there's some irony in the fact that as avenues for expression have increased for all of us through the internet, this actually leads to more regulation of it by schools, and that the authority for schools, as in loco parentis, grows and reduces the room for parental control and supervision.
I think that the two things I'd say are that the internet is an extra option. People still do have the option. I mean, students in high school still have the option of doing what people did in my day, that is, express their views to their friends and classmates at parties, social gatherings off campus. That there's no requirement that everything a student thinks and wants to communicate has to be communicated to the broadest possible audience. But I think the flip side is off-campus speech has a much greater tendency now than it did then to affect the operations of the school, simply because it can be made available to a vast audience. Not with respect to the snap, it's different, but a lot of online speech will literally appear on students' phones when they're back in class at the next school day. So I don't think it would be untoward for the court to take account of that potential effect of off-campus speech in deciding what the constitutional rule should be.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Stewart. I strongly share Justice Breyer's instincts when he mentioned that we probably can't write a treatise here and shouldn't write a treatise here and can't foresee all the things that could arise and a lot of the hypotheticals that have been raised. So I just want to get your reaction. If we just simply said the First Amendment does not categorically prohibit public schools from disciplining students for speech that occurs off campus, period. It may matter that the analysis here involves, or the situation here involves a team, not just the school more broadly, period. Remand. Is that enough?
I think that would be enough. It would probably be helpful to say, with respect to online speech in particular, the location from which the speech was posted is ordinarily going to have no significant effect on the likelihood that it will cause substantial disruption. But we entirely agree that the court shouldn't be writing a treatise, and we particularly agree that this is not the occasion for the court to try to decide how the close cases involving in-school speech ought to be dealt with.
And then I think you mentioned this, but the proportionality of the sanction here that I mentioned to Ms. Blatt, that, I guess, how do you see that fitting in at all, if at all, to the constitutional analysis? And maybe the answer is not at all.
I think that The length of the suspension doesn't factor into the First Amendment analysis. It might conceivably be the basis for a due process claim. As I indicated earlier, I do think the fact that BL was suspended from the cheerleading team rather than from school is significant. This would be a much harder case for the school if BL had been suspended from school entirely, because that punishment would rest on the idea that no member of the student body could acceptably have said this, and that would be a much harder case. What made the speech objectionable was that it was coming from inside the team.
Justice Barrett?
Mr. Stewart, I want to go back to Justice Kagan's hypothetical about sharing the answers to the geometry homework after class. You said that would be school speech. Do you think it's speech to pass on the answer key?
Yes, I think it would be speech.
What about threats to the school? You know, I'm going to come in, I'm going to bring a gun to school tomorrow and you know, open fire.
I think they would still be considered speech. Now, things like true threats may not be constitutionally protected, but that's not on the theory that they aren't speech. And I think it is important in the school context that you could, if you had a student who, in his off-campus posts, was trying to cultivate a vaguely menacing persona and was careful not to say anything that rose to the level of a true threat, but that was still intended to put his audience in fear, that's the sort of thing that a school ought to be able to regulate.
But that's also the kind of thing that the authorities could regulate if there was someone who was discovered online threatening the school or menacing the school and seeming like it could be a risk, right?
I mean, again, if the communication rose to the level of a true threat, something that could be punished under criminal or civil law, even if an adult did it, yes, that would be true. But the circumstance we have in mind is...
Let me ask you one, my time's going to run out. Could a school seek a waiver of First Amendment rights for participation in an extracurricular activity like cheer?
No, I don't think that the school could seek a blanket waiver. And so, for instance, if BL had been suspended from the cheerleading team because the coach disagreed with her political views, that would be impermissible. That would be a clear violation, even though the only sanction was removal from the extracurricular. And it would be no different if the school tried to extract a waiver in advance of the right to engage in speech that had no inherent connection to the school or the team.
Thank you.
Minute to wrap up, Mr. Stewart.
Thank you, Mr. Chief Justice. We've been discussing the school speech cases as though they were a doctrinal island, but I think it is worth pointing out that school speech is only one context in which participants in government programs can be made to accept speech restrictions that couldn't be imposed on the general public. So if I, for example, posted a message online that tracked the text of BL's SNAP, but instead of school, softball, and cheer, I put DOJ, law, and the Supreme Court, that would be constitutionally protected speech. But DOJ, as my employer, could certainly take the position that that was inconsistent with my job as a DOJ attorney. And that would rest in part on the fact that my employment at DOJ is voluntary on my part, but it would also rest on the fact that communications like that would have a much greater destructive tendency coming from within the department than from the outside. And the same principle applies here. Thank you.
Thank you, counsel. Mr. Cole.
Thank you, Mr. Chief Justice, and may it please the court. At its core, the First Amendment prohibits content discrimination. Its bedrock principle is that a speaker can't be punished because listeners object to his message. Tinker announced a narrow exception to those principles. It allows school officials to punish speech based on its content if listeners object or might object in a disruptive fashion, but it is limited to school-supervised or school-sanctioned settings. This court's school speech cases are called that for a reason. The authority they recognize is justified by and limited to the special characteristics of the school environment. So schools can prohibit pro-drug messages at school, but not elsewhere. They can ban profanity at school, but not at home. So, too, they can punish disruptive speech at school, but not at a convenience store on the weekend. Expanding Tinker would transform a limited exception into a 24/7 rule that would upend the First Amendment's bedrock principle and would require students to effectively carry the schoolhouse on their backs in terms of speech rights everywhere they go. It would also directly interfere with parents' fundamental rights to raise their children. A father shouldn't have to worry that if he brings his daughter to a Black Lives Matter protest about mistreatment of a black student at school, and she posts a photo on Facebook, she might be suspended based on potential disruption at the school. BL was punished for merely expressing frustration with a four-letter word to her friends outside of school on a weekend. Her message may seem trivial, but for young people, the ability to voice their emotions to friends without fear of school censorship may be the most important freedom of all. I welcome the court's questions.
Mr. Cole, that sharp line I think you're trying to draw between on-campus and off-campus, how does that fit with sort of modern technology? I mean, if a text or a snap that you send from the park and it's read in the cafeteria, is that off-campus or on-campus?
So if you're, our test is the test that this court applied in Morse versus Frederick, which is if you are under the school's supervision or sanction, the school has the authority that the school speech case is given. And if you're outside of the school's supervision or sanction, then the same First Amendment rights apply to you as apply to everybody else.
Well,
the internet doesn't change that, Your Honor. I mean, the internet, if anything, the internet underscores the importance of assuring that kids outside of school have the right to speak freely, because that's where kids speak. They speak to their friends. They share their most intimate thoughts on the internet with their friends. If any time they do that, and that means that somebody in school at some point might read it, the school can therefore regulate it if it's a swear word, or if it's disruptive, or if people object to it in school in a way that causes problems for the school. Then kids won't have free speech. Period. They will essentially be carrying the schoolhouse with them wherever they go. It would essentially reverse Tinker.
You say in your brief a fairly obviously strong defense of the First Amendment, but then you say that the First Amendment rights adjusted for youth and context. And at that point, I suddenly think, well, we're just back in the sort of multiplicity of factors, and nobody can tell quite exactly where any clear lines are. What do you mean by adjusted for youth and context?
So this court has said that unprotected categories of speech can be adjusted for youth and context. It said it in the context of threats. It said it in the context of obscenity. So, for example, what is threatening to a 5-year-old is different from what's threatening to an adult. What is harassing to a 12-year-old girl is going to be different from what's harassing to a 25-year-old. So those kinds of adjustments, I think the law already recognizes those sorts of adjustments. Our point is you don't need the blunt instrument of Tinker to deal with the problems of off-campus behavior that might have an effect in school, because the First Amendment doesn't stand in the way. It permits regulation of threats. It permits regulation of bullying, harassment, cheating, as long as those are carefully confined by the existing First Amendment doctrine.
You said the blunt instrument of Tinker. I'm not sure it's so blunt. I mean, we've had trouble so far, I think, in figuring out exactly how it applies in the present situation. But just so I understand, no matter how disruptive a particular speech activity off campus, or I gather, on a Snapchat is to the school, it has no choice but to tolerate that because it can't take any action against the student.
Your Honor, it can't take action based on Tinker. It can take action if the First Amendment permits it to take action. So if it is harassing, it is severe and pervasive in a way that interferes with equal access to education, they can take action consistent with the First Amendment. If it is bullying that is severe or pervasive enough to interfere with access to education, they can take action consistent with the First Amendment. If it is aiding or abetting cheating, they can take action consistent with the First Amendment. The simple rule is When you're inside the school, when you are under the school's supervision, the school has broad authority based on disruption alone. But outside of the school's supervision, the First Amendment governs, and the school has the same authority that the city would have with respect to regulating speech that is not under its supervision. That doesn't mean it can't take action. It just means it has to do so consistently with the First Amendment, rather than what I would say is a blunt instrument. Just call it disruption, and that's the end of the matter.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Cole, you a number of times have said, you've mentioned that the location of the conduct or the speech at school, under the school supervision, et cetera, isn't that complicated by the internet and by social media? And you could send the exact same messages that could cause problems from your local 7-Eleven, or you could send to classmates who happen to be in class. You could send it over the weekend, but it still has a permanence that would certainly allow it to be used in class. So I don't know how you locate the conduct in school versus out of school when you have social media.
Thank you, Justice Thomas. I think you do it the way this court has done it in all the school speech cases. It said, does the school exercise supervision over the speaker? If it does, it can regulate it subject to enhanced power. If it doesn't, it can't. So bong hits for Jesus could be regulated because it was in a school-supervised event. But if it was put on Facebook, it couldn't be punished.
So does the speech occur when, and I'm sorry to interrupt you, but does it occur when it's written or posted or when it's read or downloaded?
It occurs when it's when the speaker acts. And of course, schools are perfectly permitted to ban cell phones, et cetera, in school. And indeed, Mahanoy High School does precisely that. So the question is the speaker under the supervision of the school? And if the speaker's under the supervision of the school, you can stop him from swearing. If the speaker's under the supervision of the school, you can stop them from publishing an article about teen pregnancy. But if the speaker is at home on the weekend, you can't stop her from publishing an article about teen pregnancy, and you can't stop her from swearing. Her parents could, and it's her parents' job to regulate, not the school's job at that location.
So if the speaker sends an email that is opened, sends the email over the weekend, but it's opened on Monday morning in math class, as far as you're concerned, the speaker is not under the supervision of the school.
But the speaker was not when the speaker spoke is the relevant question.
Okay.
And again,
so let me go to another area just briefly. Is there any difference between the regulation of athletes or participants in after-school programs, as Justice Sotomayor pointed out? Is there any difference between that organization, after-school organization or activity regulating a student's conduct versus the school regulating the overall student body population?
So I think with respect to whether Tinker should apply, no. That is, Tinker should apply in school-supervised and sanctioned settings, which would include at practice or at a game, et cetera, on the bus to the game, and not when a person is sitting at a convenience store on the weekend out of season. But I do think there's a separate question, Justice Thomas, which is independent of Tinker, and the Court of Appeals addressed this as a separate question. After it decided Tinker doesn't apply, it didn't end the decision. It went on and had a full separate section on whether the school can impose conditions on voluntary participation in the activity, and whether she violated those conditions. And it looked at that question, which is a separate question, and it found that she didn't violate any of the conditions that were imposed upon her, and that was the end of the matter. And the petitioners did not seek appeal in this court of that part of the question. So I do think there's a serious question of what sorts of conditions can a team impose on voluntary participation in that activity. But that question is not posed here because it's not part of the question presented. and it's not part of the question presented because they lost on that below. The court found she didn't violate any of the rules that she agreed to follow, and they didn't appeal on that matter.
So let me ask you one last question. You mentioned that disruption, I think that's your term, the term that we've been using, can be regulated. Would you allow, under your formulation, a school to take preemptive steps to prevent disruption, or does a school have to await disruption before it can respond?
Well, no, absolutely. It can respond to predictions of disruption, reasonable predictions of disruption. That's what the court said in Tinker. You don't have to wait for the disruption, but there does have to be a reasonable prediction of disruption. And as to whether,
what's a reasonable prediction?
Well, what the courts have done is they've looked at evidence of whether or not the speech itself might lead people to be offended in a disruptive fashion. And so if in the past people have been offended in a disruptive fashion, you can now silence the speaker.
Thank you.
Justice Breyer?
Thank you. The difficulty I have, I've already mentioned. A few years ago, a superintendent of schools, I think in San Francisco, said, you know, schools have changed a lot, the public schools, since when I went there. He said, today we don't just teach classical subjects. We're there to help the child have adequate health, in many cases to see that he's adequately fed. In quite a few cases, we become a caretaker, and we don't want to send them home immediately because there's nobody home. And we have to plan after-school activities. There are dozens of areas that didn't used to be thought of as within the purview of the public school. Today, in many places, they are. Now, add to that the Internet, and the Internet not just listening to teachers, but also doing homework, and also writing papers, sometimes vaguely defined, and sometimes. How do I get a standard out of that? I'm frightened to death of writing a standard. And Tinker, after all, doesn't really write a standard. It just says you can't regulate school unless it substantially disrupts or hurts somebody else. It doesn't say, if it does, that you can do anything you want. You still must use some kind of test like proportionality or something else. And I can mention that often outside of school, it's the parent's job, not the teacher's, if, by the way, there are parents in the house, etc. And I can mention the differences and say, take those into account. But I do not see how to go beyond that, and any suggestions you have will be welcome.
Sure, Justice Breyer. I think it's important that there be clear lines. That's why the Third Circuit issued the decision it did, to make sure that there were clear lines. Within the context of school supervision, whether it's an after-school program, whether it's a class trip, whether it's in the classroom, Tinker applies. And Tinker does mean that the school can shut down a speaker if those words are going to lead to disruption, period. Whether it's political, whether it's religious, that's the state of the law in the cases below. I don't know where the other side gets this exception for political or religious speech. It just doesn't exist based on the case law. But outside of school, the priority is not to give the school discretion to regulate kids' speech. It's to protect people's freedom of speech outside of school. So our line is I think, quite simple. In school, you can apply Tinker. Out of school, you can't. What does that mean? It means you can't punish out-of-school speech because listeners in school might be disrupted by the message. It means you can regulate threats, bullying, harassment, and cheating. But it says that when you're doing that for out-of-school conduct, you follow the same rules that everybody else follows, with some adjustment for the fact that it's kids that are involved. But what we have then is a tailored approach which deals with the specific problems at issue rather than a sledgehammer approach which says we're not going to try to define bullying or harassment or cheating or threats. We're just going to say if the school can call it disruption, they can punish it, even if it occurs on the weekend. I think that's a very, very dangerous proposition in terms of young people's free speech, and the court should be very clear, as the Third Circuit was.
Thank you very much.
Justice Alito?
Mr. Cole, there is a huge gap between the broad and very important free speech issues that have been briefed and discussed this morning and the particular incident involved in this case. If we're going to address the broad issues, then I, for one, think we need clear rules that protect freedom of speech. On the other hand, if the court, having decided to take this case, wants to decide it without addressing those broad issues, of course the court could dismiss the case, and I assume you wouldn't have an objection to that. But if the court doesn't do that, could the court do something along these lines? Say, Tinker applies in the school. It says nothing one way or the other about what a school may or may not do to student speech outside the school. We look at the particular comments made here. They're made in colorful language, but substantively they boil down to something like, I have no respect for the school, I have no respect for the cheer squad, I hate the school, I hate the cheer squad, I also hate my private softball team. A school can't discipline a student for off-campus speech that does no more than say, I hate the school, I have no respect for the school.
So, we're satisfied, Justice Alito, with a ruling in our favor. Whether you dismiss as improvidently granted, whether you say under no conceivable circumstance, under no conceivable test, is this speech proper to punish. But that, of course, is not the question that the court took. And if you're going to address the question that the court took, which is, should Tinker and its broad-based, free-floating, substantial disruption standard, which has no safe harbor, as the government puts it, for political speech or religious speech, should that be applied to kids not only when they're under the school's supervision and they're captive and they're more vulnerable, but should it apply to kids on the weekend, in the middle of summer, when they're talking to their friends on Snapchat? In essence, should the speech rights of young people be constrained throughout their lives as much as it is constrained in school? Schools are areas of strict discipline. They should be, they have to be. But kids shouldn't have to carry that discipline out with them when they're hanging out with their friends on the weekend. And that's the approach that both the petitioner and the Solicitor General would put forth. We're asking for a clear line, as the Third Circuit said, that furthers the really, I think, critically important interest outside of the school context, that we protect free speech, give kids the breathing space they need to be able to talk candidly and honestly, to share their emotions, to share their feelings, even about school, without fear that some administrator is going to say, oh, well, that was disruptive, or that's going to lead somebody else in school to be upset, and so we're going to punish you.
You mentioned bullying, and I'm concerned about comments that do touch on important issues but relate directly to a student. So is there anything that a school can do about that? You say, I guess, that the school has no more authority in this area than other government officials. So what can other government officials do about that without violating the First Amendment?
There are bullying codes throughout the country. They're generally limited to the school environment, just as sexual harassment is generally limited to the employment and educational context. So it may be a context-specific concept, but I think what schools can do is they can punish those who bully in ways that violate a constitutional prohibition on bullying. And we think a prohibition on bullying that mirrors the prohibition on harassment by being limited to severe or pervasive interpersonal aggression that interferes with access to education could well satisfy the First Amendment. This court hasn't addressed that yet. But what the petitioner's approach would do and what the Solicitor General's approach would do is say, we don't even have to address the question of how you define bullying, because we'll just call it disruption, and the school can regulate it wherever it happens. And that makes no distinction between what's mean and what is bullying. And there are important distinctions to be made there, and I think the First Amendment requires them.
Justice Sotomayor?
Mr. Coe, the problem with your line drawing is we have traditional categories, fighting words, obscenity, truth threats. We even have definitions of what constitutes sexual harassment. The level at which speech has to arrive to meet those standards is very, very high. And I'm dubious that most of the conduct that teenagers engage in would fit any of our traditional categories. So let's talk about harassment, okay? Common episode, I think I read it in a newspaper. A young girl is subjected to, each time she goes out of the house, whether she's in the playground, not the school playground, or walking to school, with a group of classmates walking by and saying, "You're so ugly. Why are you even alive?" That's not a true threat. They're not threatening her with any bodily harm. It is not harassment if they're just speaking. So, and they're not interfering with her movement to or from school. Why that would be the kind of situation that I don't see a First Amendment category fitting. So under your theory of this case, would the school be powerless?
Absolutely not. The school would be permitted to regulate that conduct if it satisfies a First Amendment, a permissible definition of bullying. And we think a First Amendment permissible definition of bullying
is what?
Severe or pervasive interpersonal aggression.
What's aggressive about
with access to education, which is, in fact,
counsel, please stop. What's aggressive about it? It's basically walking by someone and saying, "You're ugly. Why are you around?" There's a lot of conduct that comes to the edge. You're now asking schools to determine what is constitutional in terms of misbehavior by students that they can attempt to control or not control?
Your Honor, within the school context, all they have to find is that it's disruptive. You could be, one student could be being mean to or teasing a student next to them, and the school can come in because it's disruptive, period. End of story, and that's what.
But you're saying they can't do it if that's happening outside the school.
That's right. That's right. Because outside of the school, the school doesn't exercise supervisory authority. The parents do. Outside of the school, the child has the protection of its parents. Inside the school, it doesn't. Inside the school, the child is captive. Outside the school, it's not. And so that doesn't mean you can't deal with bullying and harassment.
Counsel, you said to me that there could be conditions to being a member of a team, correct?
Yes.
Could one of those conditions be that you won't post foul language on social media?
I think the question would be whether that's necessary or even reasonable in terms of the purposes of the team. So if it were, yes.
This school code, it doesn't go far enough away, but it says we want the highest, must earn the right to represent the school by conducting themselves in such a way that the image of the school district would not be tarnished in any way. Our cheerleaders or team members using foul language on social media or at any school function would be a tarnishment. You won't do it, or you'll be punished. Is that a contract that's enforceable?
So I think the That is that's a question that's outside of the scope of the question presented, because they did not petition from the determination that she didn't in fact violate those rules. She spoke out of season. She did not speak at an event. But yes, I think teams have quite a bit of leeway in terms of imposing conditions on players, as long as they're set out in advance and the players agree to abide by them, and they're reasonably tied to the needs of team unity.
So why isn't, I know that what the court found below, but one of the things that it says here, the negative information rule of the cheerleading rules provided, there will be no toleration of any negative information regarding cheerleading, cheerleaders, or coaches placed on the internet. Why isn't what your client did a clear violation of that part of the code?
The Court of Appeals found that there was no information whatsoever in what she presented, and again, the petitioners did not appeal that determination.
Justice Kagan?
Mr. Cole, you're making Tinker basically a geographic test. And it's possible to read it that way, but it's also possible to understand Tinker as a decision about what's necessary for a school's learning environment. And it might be that student speech that occurs outside of school is sometimes going to cause fundamental problems, disruption of the school's learning environment. And I guess then the question is why we shouldn't acknowledge that and allow a school to deal with it.
So, Justice Kagan, our test is not a geographic test. It's a supervision test. It's the test that this court has applied in all the school speech cases. And I think there's two reasons. The first is Tinker is an exception to the bedrock principle that you can't punish a speaker because the listeners objected, even if they object disruptively. If you take away the line between what happens under school supervision and what happens outside, you have turned the exception into the rule for 50 million public high school students. The second reason is that this court's school speech cases are contrary to that notion. The article about teen pregnancy that this court said in Hazelwood could be censored because it was in a school-supervised newspaper. If the student went home and published the same teen pregnancy article on her own private blog, it would have the same concerns, the same effect. The concerns were about privacy of other students, and yet the school couldn't regulate it. Swearing, or bong hits for Jesus. The bong hits for Jesus sign, in terms of promoting drug use, would have the same effect if it was put out of the kid's bedroom window while the students walked by on their way to school, or put on his Facebook page. And yet,
Mr. Cole,
very clear. You can't.
I mean, those are some easy cases, but you've also been asked about bullying cases, harassment cases, and you've tended to say, well, sure, don't worry, you can deal with that because there may be constitutional codes that are anti-bullying or anti-harassment, and there may indeed. But I think we have a general sense that schools have more latitude over this kind of speech than other government officials. So I'll just give you one example. Suppose that there are boys in a school who have a website and rank all the girls in the school on matters of appearance and such things, or maybe talk about their sexual activities. And we wouldn't put people in jail for that, outside of a school context. But it seems as though a school should be able to deal with it. Why not?
I think a school should be able to deal with it. And I think that's what the bullying laws actually reflect, that intuition. There's no prohibition on bullying generally between adults.
Well, let's say that this, I'm just stipulating that there are some categories of speech that we could not punish outside the school context, and ask you if you can't imagine cases where even though we couldn't punish it outside the school context, and I think mine is a good example. You can't put people in jail for commenting on other people's appearance, but shouldn't a school be able to deal with it?
So yes, a school should be able to deal with it, but the way to do that is with a test that addresses that particular problem. As Justice Alito's opinion in the Sachs case for the Third Circuit said, the mere fact that you call it harassment doesn't mean the First Amendment goes away. You still have to assess, is it narrowly tailored or does it punish too much speech? And that question could well be affected by the school environment, could well be affected by the fact that kids are involved, but you should ask that question and decide that question with respect to a particular problem, like bullying or harassment, rather than adopt a broad brush, free-floating disruption standard that, yes, it might reach that, but it also reaches political speech, it reaches controversial speech.
Well, what do you think about the SG's test, which basically says, when you get, there is a distinction between in school and out of school, and we can't punish anybody for wearing a Confederate T-shirt outside of school, but once the outside of school speech is really about the school and affects the operations of the school, then it is subject to tinker again.
I think the SG's test is the vaguest test that's been put before you. It would require schools to distinguish between speech that is spoken to a student as opposed to speech that is targeted at a student, speech that is about a program as opposed to speech that is targeted at the program. It would allow schools to define in an unreviewable fashion what is essential to any school program. So suppose the
Thank
school
you, Mr.
said,
Cole. Thank you.
Justice Gorsuch?
Yeah, I'd like to follow up with where you left off with Justice Kagan. I'm struggling to understand the delta or difference between your test and the petitioners at the end of the day with respect to off-campus speech that results in a person on campus being denied an educational opportunity, which is what I understood your test for off-campus bullying to be. What is the difference between that and a substantial disruption on campus test?
I think there's really two basic differences, Justice Gorsuch. The first is that their test is disruption, covers anything that anybody says off campus that might have an effect on campus. So let me just pause there.
I'm sorry to interrupt, but let me just pause there and say, rather than substantial disruption, you would say it has to disrupt an individual's educational opportunity. I'm just not sure what that difference is.
Right. So no. Maybe I misstated. Our position is that bullying can be regulated like harassment, consistent with the First Amendment, where it is defined as interpersonal aggression so severe or pervasive as to interfere with access to education. All of that is critical to that definition. It's not just had an effect on the school, whereas their test is just had an effect on a school, and therefore their test would encompass someone who puts up a sign that says Blue Lives Matter More, or somebody who criticizes the coach for physically abusing players, or somebody who organizes an off-campus protest of a school's COVID policies. All of those things could be disruptive, but they wouldn't be bullying, they wouldn't be harassment, they wouldn't be threats, and under our rule, they would be protected.
Why wouldn't they be bullying? Under your definition, would severe interpersonal, I'm sorry, I missed the rest of it, but it strikes me as, you could easily take a lot of those examples and put them in that bucket.
I don't think so, Justice Gorsuch. Putting up a sign that says Blue Lives Matter More is not bullying under any reasonable definition, nor is whistleblowing about a coach's physical abuse or calling for a protest of a school's COVID policies. But all of those things could be disruptive in the school. And under their test, they could therefore punish the speaker for expressing those messages. The other difference between our test and their test is that our test would require careful definitions of bullying, harassment, and the like, rather than just waving your hands, calling it disruption, and going away. And the problem with that is then you're not distinguishing between, ordinary mean comments or teasing and bullying and harassment. And this court in Davis and Justice Alito in the Sachs decision said, you have to make those distinctions if you're going to be consistent with the First Amendment.
But you would agree, if I understand it, though, that there could be some school-specific First Amendment regulations, right? I mean, as Justice Kagan pointed out. Yeah, all right. And then let me ask you, just to turn to another topic and back to the facts of this case. why doesn't it make a difference that the speech here was addressed by, in the context of an extracurricular activity, and that the standards there may be different from higher than what may be required of all students in the school environment?
So I think it can make a difference, Justice Gorsuch. It doesn't make a difference to the question presented, which is simply whether Tinker applies out.
No, I understand that. I'm moving now from the general to the specific if we're going to go down the road of writing a narrow opinion.
Right. So to the specific, I think there are serious questions about sort of what sorts of, because extracurriculars are voluntary, schools can require students to agree to certain kinds of conditions on participation in the program, as long as they're set out in advance and consistent with the First Amendment. And so, for example, I think a school could say, if you're going to play on our team, you can't personally demean other players. And if they set that out in advance and the student agrees to it, and then the student does it, they can punish the student. If they don't set that out in advance and the student says something demeaning, they can bring the student in and say, hey, that's not acceptable. The condition for playing on this team is that you don't demean others.
So that the only,
and then there's an advance rule. If they do it
the
again,
outcome of this case hinges on whether there was a policy in advance?
Well, it does if the justification for the regulation is voluntary participation and agreement by the person to a certain set of conditions that would otherwise not be permissible. But again, that is a separate issue. The Third Circuit addressed that issue after it decided Tinker didn't apply. It didn't say the case is over. It said there's a second issue. It may be, even if Tinker doesn't apply, that if she violated rules that she agreed to, that's a permissible basis for her expulsion from the team. And then they looked at it and they found she didn't actually violate any of those rules. And again, petitioners did not appeal on that question.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Cole.
Morning.
I obviously think it's unfortunate this spiraled, this case, the way it did, and completely understand the young woman's reaction to being upset with the decision. As I mentioned to Ms. Blatt, I think that's entirely typical and widespread for decades and decades when kids are disappointed by something like that. And then the coach's reaction, it seems like an excessive sanction, but we're not there. We don't know all the circumstances and don't want to second guess that too much. But I guess I'll start where Justice Gorsuch was discussing with you. It just seems entirely different to be talking about a team and not a school, and I'm just not sure, and I'm going to ask follow-up questions about this. I'm really trying to figure out the practical difference for courts in the wake of this case between if we adopt your test and Ms. Blatt's test. So team, and then move on to that if you can.
So our test is the Tinker disruption standard applies within the school supervised settings, not outside. So with respect to teams, if you're on the field, if you're at practice, if you're at the game, if you're on the way to the game, if you're, then you are subject to Tinker and disruption applies. If you're at a convenience store on the weekend, Tinker does not apply.
So suppose
End of story.
Keep going.
End of story. And the fact that you're on a team doesn't change that question, because there's nothing about your involvement in a team that affects the Tinker analysis. But there is, I think, a separate and independent question, which is what sorts of conditions can a school impose on a person if they join, say, the football team or the pottery club? And those conditions might be different, and and I think reasonable conditions are going to be permissible. And here they set forth some conditions. She agreed to abide by those conditions, and she didn't violate any of those conditions. This happened out of season. She did not do anything while she was in her cheerleader uniform. She did not post any negative information on the internet. She basically expressed her frustration, as I'm sure you did when you had disappointing games, and as I did when I had disappointing races, and that didn't violate any of the rules. And that's the end of the matter, because they have not sought any review of that. So in a separate case, you might take up the question, what sorts of rules are reasonable to impose on involvement in a team. What I will say is that if you look...
Sorry to interrupt. Suppose in this case the Snapchat had been a racial epithet about the coach.
A racial epithet about the coach, I think if they have a rule that says you can't demean other players or the coach, you can't engage in insubordinate speech to the coach or about the coach, then they could punish her. If they don't have a rule, they could bring her in. They could say that is totally unacceptable.
But they can't punish her for racial epithets. I guess this goes to Justice Gorsuch's question as well. Unless they have a clear enough policy in advance, you can't punish a student who uses racial epithets in a Snapchat about the coach or other players, in your view?
I think here's what you can do. I think you can bring that person in and you can say, that is unacceptable. If you have not set that condition out in advance, you then set it out. And then if they ever do it again, they're off the team. So you can definitely deal with it in a way that maintains the authority of the coach and the unity of the team. But if the justification for additional requirements on team involvement is that you have chosen to join the team and therefore you can be asked to sacrifice some of your First Amendment rights in advance, well, then you have to be told what you're sacrificing.
I just want to pick up on Justice Breyer and Justice Alito because maybe I don't want to be misunderstood on what I'm saying. I think you can answer the question presented here very clearly without writing a treatise, and that's the point I was trying to make. And the question presented is just whether Tinker applies off campus. We could answer that yes or no. If we answer it yes, obviously that will answer the question presented. If we answer it no, here's the point for you. You still have all these exceptions that allow, as I understand it, the First Amendment, that mean that the First Amendment does not categorically prohibit public schools from disciplining students for speech that occurs off campus. So I think that's the point that Justice Gorsuch was making. You just do it differently than Ms. Blatt. She says Tinker applies off campus. You say Tinker doesn't apply off campus, but by the way, the First Amendment still allows the schools to regulate speech that occurs off campus in a number of circumstances. I'm just wondering whether that's worth the candle.
Well, I think it's very much worth the candle.
Well, if it really creates different results, you're just saying that as long as they write the policies in advance, it'll be...
No, not at all, not at all. I think, look, there are hundreds of Tinker cases. Virtually all of them involve suspensions for things that kids do vis-a-vis as students. There's about a handful of team cases. So that's a different category. I don't think it's presented by this case for the reasons I've indicated. With respect to the basic question presented, which is should Tinker apply off campus, the delta between our position and theirs is that ours says ours protects politically controversial speech. Ours protects whistleblowing. Ours protects venting frustration, on the weekend. And ours does not say that schools can't address off-campus speech. It just says if it's off-campus, you have to address it consistent with the First Amendment rules that govern that particular problem.
Justice Barrett? Mr. Cole, I want to pick up where Justice Kavanaugh left off. I want to make sure I understand your approach. Let's talk about the harassment example that you were discussing with Justice Sotomayor. Tinker doesn't apply off campus. Let's say, that we're in that world. And you say that the school could, much like a city official, if I'm understanding this correctly, prohibit harassment that rises to the level of interference with another student's educational opportunities. And I assume that would be judged if the school adopted. Would you envision that in a bullying statute, or would you envision that in a school-adopted policy? Start with that.
So I think the schools have generally adopted bullying policies. The states have required them to adopt bullying policies, and there are many, many such policies. And our view is those are constitutional.
Okay, so let me ask you about the test. So the policy comes from the school. So the school adopts a policy, say, about bullying, and then it gets challenged when a student is disciplined for off-campus bullying. Let's imagine Justice Sotomayor's example of the, you're so ugly, and it arises to the level where the child just can't go to school anymore, or the example about the disabled student who was taunted with sexually graphic images on his way home from school. That's subject to a First Amendment challenge, and what you're saying, well, there's a compelling state interest, but it's narrowly tailored. Is that what you're envisioning? Content discrimination, but...
Yeah, our view is just as the sexual harassment law with respect to hostile work environment is permissible in terms of prohibiting severe or pervasive harassment that interferes with equal access to the employment place, so too a bullying law that prohibits severe or pervasive interpersonal aggression sufficient to interfere with access to education would be constitutional. I think it could be constitutional under Giboney, as this court suggested in RAV with respect to sexual harassment, or it would be narrowly tailored to a compelling state interest. But if you define bullying, as some of the codes do, as anything that would cause emotional harm, without these kinds of guardrails, I think that's not consistent with the First Amendment. And so the court ought to address that in an appropriate case and determine what the appropriate definition of bullying is.
What about cheating?
Doesn't involve bullying.
How does cheating fare? Justice Kagan's example of the student who goes home and emails out answers to geometry homework. So Giboney allows for the prohibition of speech integral to prohibited conduct, and that covers aiding and abetting. So aiding or abetting cheating is just not protected at all under Giboney. Well, but what about, let's see, if you're thinking about something that's a crime, right, aiding and abetting is different, but the school can define in-school offenses. So it can define cheating as an offense, but what if it defines, demeaning classmates as an offense?
Well, I think it has to. I think what Giboney is about is speech integral to prohibited conduct.
Right,
so
and what if it's prohibited conduct? But what is to say?
Versus speech.
Wait, I'm sorry. Go ahead.
The difference is conduct versus speech. The rationale of Giboney is if you're regulating conduct, the fact that there's some speech integral to that conduct doesn't make it a First Amendment problem. So if and schools.
So the cheating is your answer is that the cheating is conduct. I mean, the circulation of the answers is conduct.
Cheating is conduct, however it's done, and if you aid or abet cheating through the circulation of answers, yes, it can be prohibited.
Okay. What would be wrong with a test like this? One of your problems is that it's difficult to define the school environment and what constitutes the school environment. What would be wrong with saying that the school environment exists when the student is relating, not just supervisory, I mean, that's narrow. What about when the student is relating to the school in the student's capacity as a student? So if the student is directly communicating with the school, sending emails to the school, sending emails to a teacher at the teacher's school email account, would those be within the school environment on your definition?
Yes, because you would be subjecting yourself to the school's jurisdiction. If you call the school, if you send an email to the school account, you are now subjecting yourself to the jurisdiction. But if you send a text to 6 of your friends who happen to be classmates and you do it on the weekend, you're not subjecting yourself to the school's jurisdiction, and you shouldn't be treated as if you're in school.
Thank you.
A minute to wrap up, Mr. Cole.
Thank you. Everyone agrees off-campus bullying, harassment, and threats, properly defined, can be regulated. The difference between the other side's tests and ours is this. Ours would protect political speech, whistleblowing, and venting frustration outside school, even if a principal predicts it will lead to disruption. Theirs would not. Ours would preserve the rule against content discrimination and the heckler's veto outside school. Theirs would not. Ours would provide breathing room for free speech outside school. Theirs would empower school officials to monitor everything students say to each other anywhere. And ours would require clear definitions of off-campus bullying and harassment consistent with First Amendment principles. Theirs would call it disruption and dispense with further definition. The fact that petitioner claims it can punish BL for a momentary expression of frustration on a weekend out of school and out of season shows how sweeping its approach is. Its rule would teach students they can never speak candidly with their friends without worrying that a school official will deem their views potentially disruptive and suspend them or otherwise punish them. That is exactly the wrong lesson to teach. Thank you.
Thank you, counsel. Rebuttal, Ms. Blatt?
Thank you, Mr. Chief Justice. There's some sort of twilight zone going on when the head of the ACLU says that schools allow heckler's veto, punishment for whistleblowing, any kind of reporting, any kind of criticism. All that matters is someone is offended. And you have the Biden administration and the school district saying, that's not true. That's not what Tinker allows. Now, Mr. Cole said the case law allows us to act like Soviets and the North Koreans. But since the Sachs opinion, the Morse concurrence, Fillmore, and Zelenak have left clear lines for schools and that heckler's veto are not allowed. And your choice is this. If you can choose to either tighten Tinker, or you can say, well, we're going to assume Tinker's out of control on campus, but we will leave open season on schools and complete chaos as to what their test allows. Under their view, all 50 states define bullying in terms of Tinker. You have the same email chain that would toggle on and off campus, and you would have the Tinker test applying when there's some on-campus speech. And I don't know what applies. I think Mr. Cole said it's the Tinker test, but he's afraid to use the Tinker word because it's scary, and it shouldn't be. You're much better off cleaning this doctrine up. Justice Kagan, you had amazing questions about school speech. Remember, our test is the audience has to be the school. So all of your speech, if it's to the press, the police, your pastor, your family, etc., none of that is school speech, even if it involves the school topic. Justice Barrett, on threats. The facts in Bethlehem in Pennsylvania and Bell, nobody knew whether that was a threat. The police were sort of involved. It is not fair to the parents of those other kids to have schools fumbling around. I don't know what this applies. Before we had Tinker, part of the threats were on campus, part were off. It was on the internet. Let's look at where she drafted it. Maybe she was to and from. Now let's move to the school supervision. Madness, confusion, and chaos. Please don't do this to schools. Mr. Cole said you could prevent swearing to and from school. That's nuts. You're in the dad's minivan? That's school supervision under their view. No one thinks Frazier applies there. And yet, all of a sudden when you get out of the minivan, and I guess walking to it, but maybe it depends on how far you park, Tinker is going in and out of coverage. That rule makes no sense. There's no case law on conduct that aids and abets school speech. You will have a school speech petition. You can keep denying cert, but I guarantee you the courts are going to freak out when Tinker has been the law off campus for 20 years. Thank you.
Thank you, counsel. The case is submitted.
not initiated by the federal government itself. That claim fails for two interrelated reasons. First, states acceded to the federal government's superior eminent domain authority in the plan of the convention. In our system of dual sovereignty, only one sovereign can have the ultimate authority over land when the federal and state governments assert conflicting claims. The Supremacy Clause largely settles that debate, and New Jersey concedes that its sovereignty must yield when the federal government decides to take state property. But once it concedes that, it has no immunity left to assert in the proceedings necessary to effectuate the taking. That follows from the immovable property exception, which long predates the framing. No sovereign has ever had immunity from the eminent domain authority of a superior sovereign over immovable property. It also follows from the very nature of eminent domain. Eminent domain that depends on consent is an oxymoron. Second, the proceedings here are in rem and can only augment the state treasury. This court has recognized that in rem proceedings pose a lesser threat to state sovereignty. Justices Washington and Story made the same point when the 11th Amendment was new. And of all in rem actions, eminent domain proceedings pose the least concerns. They allege no wrongdoing, they impose no liability, and they cannot be brought without federal authorization. The whole point of the proceeding is to ensure just compensation for a taking. New Jersey's effort to convert a constitutional remedy into a veto over the federally authorized taking is simply incompatible with our constitutional design.
Mr. Clement, do you have any other examples outside the area of eminent domain where the federal government can delegate its powers to a private party and then the private party can exercise those powers in a way that's inconsistent with state rights?
I'm not sure we do, Your Honor. I mean, in the sense that, I do think there is a long and unbroken tradition of the eminent domain power being delegated, or maybe the better way to think about it is that a private entity is deputized to exercise the power. And I don't think we're asking for any ruling that would extend outside the eminent domain context, but I think all sovereigns, including New Jersey, have recognized that the ability to deputize the private actors to exercise the eminent domain power is really essential to developing infrastructure.
Well, what is it that makes the eminent domain power so unique? That it's the only example we have. It's really quite extraordinary to have private parties overriding state immunities.
Well, first of all, Mr. Chief Justice, I'm not sure that's the right way to think about it, which is to say I think when somebody like PennEast acts pursuant to a deputized eminent domain power, it really is exercising the federal power directly, and it's not an ordinary citizen. I think one way to understand that is if PennEast doesn't provide sufficient compensation, it has violated the just compensation clause of the takings clause. Now, we generally don't think that the takings clause applies to anyone other than a federal actor. It applies here because distinctly you have somebody exercising the federal eminent domain authority.
Why is this such a problem? Why can't this private party join a federal officer as an indispensable party or whatever so that the federal government is part of the condemnation proceedings?
So, Your Honor, I suppose Congress could alter the statute and do that, but, Congress has been delegating or deputizing parties to exercise its eminent domain authority for well over 100 years. It's never done that, and I don't think there is any reason that they need to do that in order to save the authority. And, again, New Jersey exercises the ability to delegate or deputize private parties, and they don't appear in those proceedings either, to my knowledge.
Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Clement, could you give me the language here that effectuates the deputizing of PennEast?
Sure, Your Honor. I think it comes right from 15 U.S.C. 1717 FH, and it says when any holder of a certificate of public convenience and necessity cannot acquire by contract or is unable to agree with the owner of the property to compensation to be paid for the necessary right of way to construct, operate, and maintain a pipeline for the transportation of natural gas, it may acquire the same by exercise of the right of eminent domain.
So how is that deputizing versus simply delegating?
So Look, it's a fine line, Your Honor. I think the reason I would think of it as is better as deputizing is for two reasons. One, even if you go back to the old treatises, like I believe it's the Lewis treatise from 1888 that you relied on in your Kelo dissent, he says that it's really wrong to think about delegating the eminent domain authority because it is an inherently sovereign authority. So that's one reason I think of it more as deputizing rather than delegating. But the other reason is what I alluded to with the Chief Justice, which is it seems to me that when a private party does exercise the eminent domain authority, it is a limited purpose federal actor for purposes of the takings clause. And by parity of reasoning, it seems like it is also a federal actor for purposes of the 11th Amendment.
Is there anything in any of the pleadings that suggests that, say, that PennEast is bringing this on behalf of itself and the United States?
I don't think we really put it in those terms, Your Honor. I guess what I would say, though, is one thing that is evident from the pleadings is this is principally an in rem proceeding. So, the proceeding is PennEast versus 1.90 acres of land for purposes of an easement. So I do think it matters that this is not an action directly against the state in personam, but is an in rem action.
I think you might have a better argument, in rem argument, if possession of the land or the rem was in the custody of the courts. But this is the interest we're talking about is in New Jersey, and it's under either possessory or control of New Jersey. It's not under the control of a court.
Well, two things, Your Honor. First, 40 of the 42 parcels here are not possessory interests of the state. They're just environmental easements and the like. And second, I think as a matter of doctrine, immovable property in the jurisdiction is always in the possession of the court. It's not like personal property where maybe the court has to issue in personam process to a defendant to bring the property within the jurisdiction of the court. The land itself is in the territorial jurisdiction of the court, and that's why there's never been a sovereign immunity defense to an eminent domain action by the superior sovereign because of the immovable property exception.
Thank you.
Justice Breyer?
There are a number of cases where this court has said if you're going to interfere with the sovereign immunity rights of the state, Congress has to do so clearly. You've read them. What are the ones, take the ones, whatever three or two or three you think are the strongest against you, and then explain to me how you distinguish them. I'd appreciate that.
Thank you, Justice Breyer. What I would say is all the cases that are looking for a clear statement are looking for it in the abrogation context. So they assume that there is a sovereign immunity that has to be abrogated. And we don't think there is any sovereign immunity here that needs to be abrogated at all. And I think that's true for two primary reasons. One is because no sovereign has ever had a sovereign immunity defense to an eminent domain proceeding by the superior sovereign, ever, in the history of the world. I mean, the immovable property exception was established well before the framing of the Republic. And so we think there's just no sovereign immunity here to abrogate for that reason. But we also think you can get to the same result simply by looking at this as not just an in rem proceeding that is against the property and not against the state, but an extraordinary in rem proceeding where there is no allegation of wrongdoing, no effort to impose liability on the state, and the action can't be brought at all unless it's authorized by the federal government here in the process of a FERC certificate.
Thank you. Justice Alito?
Mr. Clement, let's start with the reason why a state may be sued by the United States. Is this a correct understanding of the reason for that rule? When New Jersey and other states entered the Union and they read the Constitution, they saw the federal structure that was set up, and they read the scope of federal power, federal judicial power under Article 3, they had to realize that this meant that they were surrendering that portion of their sovereign immunity.
I think that's fair, Justice Alito, though I would emphasize I think what principally did it for them and what they should have read is the Supremacy Clause as opposed to necessarily Article 3. Because a case like United...
Okay, the supremacy clause in Article 3. But this was something that this court thought they must have realized when they entered the Union. This was part of the bargain. Now, I understand your argument that they must also have realized that a sovereign can deputize a private party to exercise the condemnation power, and therefore, because they were surrendering their immunity from a condemnation suit by the United States, they necessarily were also surrendering their immunity with respect to a private party that might be deputized to exercise that power. But is that a fair inference? Is it a sufficient inference? Would it not have been entirely reasonable for a state to think, look, okay, we understand we're giving up our sovereign immunity against a condemnation suit by the United States, but we don't think that we necessarily are giving up our sovereign immunity with respect to a condemnation suit by a delegate, even though this is a rule that applies in other contexts.
So, Justice Alito, I don't think that would have been a reasonable inference because the eminent domain power has always been delegable. That is something that was well established before the framing. So if they accepted at the framing, as I think they must have, because of the supremacy clause, that they would not be able to assert a sovereign immunity from an eminent domain action brought by the federal government, because they would presumably know about the immovable property exception, and they would understand that it's essentially an oxymoron to say that I'm going to assert a sovereign immunity defense against the superior sovereign who has eminent domain over everything in the realm. I think they would have understood that that was equally true whether the federal government exercised that through itself or by delegating a limited purpose federal agent.
Is that a correct understanding of what the constitutional question boils down to? In a word, because my time has run out.
Well, I think that's one way for us to prevail, but I don't think the constitutional question boils down just to that, because I do think that you could decide this case just on the ground that there is properly understood no action against the state, it's against the property, and along the lines of Hood and other decisions that have said in rem is different.
All right, thank you.
Justice Sotomayor?
Mr. Clement, perhaps I don't understand these features, and delegation is troublesome for me. And this doesn't apply to FERC, but if we didn't have FERC, could the government have delegated, in your use of the term, to a private entity the decision as to what route was necessary and to then condemn those portions of the route that it thought necessary?
So, Justice Sotomayor, I think there would be a separate question there about whether the delegation was essentially sort of, ascertainable enough for these purposes. I would say, though, if you go back to the exercise of eminent domain power historically, there have certainly been situations where the federal government gave less direction than you have here with respect to FERC. So, for example, when the railroads were built, there was, a fair amount of discretion given to the railroads to determine what land that they would be able to condemn. Now, I would say also that I think particularly when the sort of delegee has greater discretion, that's when you would probably look for Congress to put in more restrictions that certain land is off limits. And I do think when you have a situation like this where no pipeline traverses any land without the approval of FERC, and they can take into account whether, this is excessive or whether not going through this particular piece of state land would require the pipeline to be substantially rerouted, that would create additional environmental problems and the like, especially when the federal government is playing that role. It seems like most of the concerns that you have under the 11th Amendment with some private party with an unfettered right to sue are just simply misplaced.
Counsel, your adversaries point to certain aspects of a condemnation proceeding that seem to lend themselves to sovereign decision-making. I do agree with you that just a simple appraisal is different. How much is this land worth? And you could You hire a lawyer, and the lawyer helps you with that. You can hire a party that does the same thing. That's basically your argument. But how about the negotiation aspects? The state argues that there is a sovereign-to-sovereign part of this process, which is you're not supposed to start condemnation until you've had negotiation. And why should I be forced as a sovereign to negotiate with a non-sovereign?
So, Your Honor, I guess I would say that, that is a part of their concern, but I think it's an odd concern because, the sovereign immunity, the 11th Amendment immunity, doesn't kick in until you really get to court. And, honestly, if at the end of the day their problem was with that they had to negotiate with us, I still don't think that that would sound in any kind of normal sovereign immunity. I also think that it's not really the challenge that they have preserved to that sort of negotiation. And I still think they would be negotiating with FERC's agent. And I think it is important to keep in mind that in this process uniquely, PennEast is a limited federal actor for purposes of the Takings Clause, and the same logic should apply to the 11th Amendment.
Thank you, Counsel.
Justice Kagan?
Mr. Clement, you told the Chief Justice that we shouldn't think of this as a case about a private party condemning land, that we should think that PennEast essentially steps into the shoes of the government. And that raises questions in my mind as to what the government involvement in this case was. In other words, was there any supervision by the government? Was there any participation by the government? Did any lawyers for the United States approve the timing of the condemnation action? Did any lawyers for the United States approve the parcels to be condemned? Is there anything that the U.S. Itself was involved in this case?
Well, Justice Kagan, I guess you have to distinguish between what happened at FERC through the FERC agents and what happened sort of after that point. And, I'm not here to tell you that after the specific route of the pipeline was approved by FERC in a process where objections were heard from all the property owners, including the state, and over 70 route modifications were made. That was all done under the auspices of the federal government. They approved the route in the certificate right down to which parcels were affected. Now, once that happens, the way it has worked for 70 years is that the certificate holder then gets to go into federal court, and certainly FERC can, by its rulemaking, sort of determine, generally speaking, when the timing is. It could, as it's suggested, it has done recently, promulgate a rule that says that the certificate holder should not initiate the condemnation proceedings until the rehearing period at FERC is closed. It could change that timing. All of that's within their control. But I don't want to suggest that FERC is kind of directly sitting over our shoulder in the district court action.
So New Jersey says that there were a whole range of things that PennEast did that the U.S. government would not have done. New Jersey says the U.S. has an obligation to negotiate in good faith while you refuse to negotiate. That you rushed to condemn the land before the route was finalized in a way that the U.S. government wouldn't have. That your interest in land valuation is different. In other words, that there were a whole set of litigation tactics or moves that a private party would have been perfectly legitimately made that the U.S. government would not have.
So, Justice Kagan, I don't think that's true. And, if you go through each of those things, we didn't do anything here in terms of the timing that FERC didn't approve. And so I don't think FERC will say we did anything wrong in that respect. And I don't think if FERC were forced to do this differently, they would have necessarily done anything different. With respect to the negotiations, the district court found that, in fact, we did negotiate in good faith here. And so I don't think that's a material difference. And in terms of the valuation and the paying of just compensation, the way the federal government has been doing this for 100 years is for some of these infrastructure projects, they think that it's just much more efficient to have the private party act as the federal actor deputy, and they're not doing that to shortchange the property owner. And I would bet if you ran the empirical numbers, the property owners probably did better. But in all events, it's something that has been done by all sides,
Thank you, Mr. Clement.
including New Jersey, for a long time. Thank you.
Justice Gorsuch?
We focused a lot on what I call structural immunity under the Constitution, and maybe a little less on the 11th Amendment. I'd just like to ask a question about that. I understand the argument that PennEast steps into the shoes of the federal government in many senses, but as I understand it, PennEast is a citizen of Delaware. That's what the lower court said. We have before us a suit in law or equity. Cole says that. So why doesn't this case fall within the plain text of the 11th Amendment itself, which limits the judicial power of the United States in cases by a citizen of one state against another state?
So thank you, Justice Gorsuch. I think there's three answers to that. One is that this is not an action against the state within the meaning of the 11th Amendment. It's an action against the property. I also think, although PennEast...
Putting aside the in rem argument, right, yeah, fair enough. Yeah, okay, put that aside.
And the second is that although PennEast is a citizen of Delaware for all other purposes, I think for these purposes it is a limited purpose federal actor, and it has liability under the Takings Clause. So I think that's another reason why the text is not a problem. And then the third reason is that even the most textualist justices, such as Justice Scalia, have kind of understood that the 11th Amendment, what it's really doing is kind of restoring the immunity that was there at the plain of the
11th Amendment does other things, has been read to do structural immunity, but just on its plain terms, we have a citizen of one state suing another state, right?
Again, I would beg to differ on both counts, which is I think what you have is a federal deputy suing land. And if you look at the principal captions of these cases below, they are PennEast versus...
But the federal deputy exists as a citizen of a state. It doesn't lose its citizenship, does it? How would that work? What authority is there for that?
I don't think it loses its citizenship, but I don't think that's the capacity in which it's suing. And as a mere citizen of Delaware, it doesn't have takings liability. It has takings liability because it is a limited purpose federal actor, and that is really the posture in which it's coming into court.
But it is a citizen of Delaware. It doesn't lose that by virtue of being deputized. It's just a deputy from Delaware.
It's a deputy from Delaware, but if there were a human being who was a federal deputy from Delaware, they would still be a citizen of Delaware, but when they walked into federal court and filed an action, they wouldn't be filing it in that capacity. And I do think that's what ultimately matters. But I also think, as to the text, obviously we put the in rem matter to one side, but, I do think that is an important distinction here. And I think this is very parallel to this court's decision in Hood.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice, and good afternoon, Mr. Clement. Just want to ask a question that might be both a softball and a fastball, but if you lose this case, what will happen?
So, Justice Kavanaugh, if we lose this case, then, this pipeline will, not be built, at least at anything like its current configuration. And depending on exactly how we lose this case, I think this pipeline, this federal interstate pipeline, until the law is changed, will, be at the mercy of New Jersey, because I don't think there is a way to reroute this pipeline in a way that doesn't implicate a state interest in land. The parcels at issue here don't implicate it, but this pipeline has to cross the Delaware River somewhere, and half of the Delaware River belongs to New Jersey. So there's just no way for this pipeline to exist under the current law. And I think that does show why there is something fundamentally wrong here. I mean, New Jersey would be operating as a property owner in this context, and yet as a property owner, they would be trying to do something that they can't do as a sovereign, which is to exercise a veto over a interstate infrastructure problem that they recognize is conceitedly legitimate under FERC's authority, at least for purposes of this case.
I think your answer encompasses this, but does that mean you don't think FERC has any way to get involved and to avoid the problem that would be in your way if you were to lose this case?
That's correct, Your Honor. I don't think there's any way short of an amendment of the statute for FERC to deal with this problem.
Thank you.
Justice Barrett?
Good morning, Mr. Clement. I want to talk about your plan of the convention argument. At least as I read the briefs, I don't see any historical support for the proposition that a state could be sued by a private party, you know, standing in the stead, the private party standing in the stead of the federal government's eminent domain power. The cases that you cite, like immovable property cases like Georgia versus Chattanooga, all kind of rely on inference. And I mean, so far as I can tell, too, it wasn't until 1876 in Cole that the federal government even instituted a condemnation action against the state. So is your plan of the convention argument not really your strongest one, and is your in rem and hood argument better?
I think they're both pretty good, Your Honor, and if I could just try to convince you that the plan of the convention argument is a little better than you suggested, I'd just point out that the situation here is almost directly parallel to the situation in the United States against Texas, which New Jersey, of course, says is a legitimate plan of the convention ceding of sovereign immunity. As a matter of fact, it took longer for the federal government to assert an original jurisdiction action against the state than it took the federal government to exercise its federal eminent domain authority in the states. By my count, the first original action against the state was U.S. against North Carolina in 1890. But in both cases, even though it took 70 to 100 years for the federal government to exercise the power, the court still looked and said, okay, going back to the framing, we understand that the supremacy clause, which is part, obviously, of the plan of the convention, has certain implications. And one implication that is here is that once New Jersey concedes, as it does, and I think it must, that the federal government has the eminent domain authority over this property, then no sovereign ever has had an immunity defense against the taking of property pursuant to the eminent domain authority by the superior sovereign without respect to whether it's been delegated.
Okay. Immovable property doctrine. Don't you think that the Chattanooga case had more to do with the fact that the land that Georgia had was located within another sovereign's borders, as opposed to here where this is land within New Jersey's own borders? Do we have to read that case your way?
Well, obviously, Your Honor, you don't have to read it that way, our way. But what I would say is I think the principle is the same, which is in both cases there's a recognition that there is a superior sovereign. The mechanism for making that recognition is different. In the Chattanooga case, Tennessee is the superior sovereign because the property is territorially within Tennessee. Here, this property is subject to the superior eminent domain claim of the federal government because of the supremacy clause. And what's so odd about New Jersey's position is they concede that the federal government has the power to take this property from them, which is the principal sort of recognition of eminent domain, yet they still think they can assert a sovereign immunity defense, and that's never been the case since before the framing.
Thank you, Mr. Clement.
A minute to wrap up, counsel.
Thank you, Mr. Chief Justice. In the end, New Jersey's position amounts to a claim that the federal government has less eminent domain authority than any other sovereign. New Jersey itself not only exercises eminent domain, but freely deputizes a wide range of utilities, including pipelines, to exercise that power and provide just compensation. The claim that the federal government is only a junior varsity sovereign was rejected in the plan of the convention. Where the federal eminent domain power exists, it is complete, and there can be no sovereign immunity defense to its implementation. Indeed, thanks to the immovable property exception, a sovereign immunity defense to the ultimate sovereign's eminent domain authority is an oxymoron. That is particularly true because eminent domain proceedings are unique in rem proceedings that assert no wrongdoing, impose no liability, and can only augment the state treasury.
Thank you, counsel. General Needler? General Needler?
I'm sorry. Mr. Chief Justice, and may it please the court, under the Natural Gas Act and this court's decision in the city of Tacoma, the courts below were without jurisdiction to resolve respondents' statutory challenge to PennEast's exercise of the right of eminent domain. By contrast, the courts below were not precluded from resolving the state's contention that the 11th Amendment bars PennEast's condemnation actions. But there is no such 11th Amendment bar. This court held in Cole that the federal government's power of eminent domain is complete in itself and that no state can prescribe the manner in which it may be exercised. That power indisputably extends to state-owned property. Indeed, thanks to the immovable property exception, a sovereign immunity defense to the and it has been established since before the founding that the sovereign's right of eminent domain includes the power to authorize private entities to exercise that right for roads, canals, and other infrastructure projects. The district court therefore may proceed with these actions to determine the amount of compensation that is owed to the state for this federally authorized taking of its property.
Putting aside your jurisdictional issue, Mr. Needler, a private party with a certificate under the Natural Gas Act, could they bring a condemnation action against federally owned land?
No, they could not, Mr. Chief Justice. There are separate statutes that deal with the acquisition of a right-of-way across federal property. The court's decision last year, excuse me, in the Atlantic Coast Pipeline case dealt with some of those issues in terms of getting a right-of-way for across federal property, and this statute would not authorize that.
Well, but I thought the idea was that the private parties are actually federal delegates, and that would be the capacity in which they would be acting.
They would be federal delegates, but they would still have to comply with the statutory structure that Congress has established for acquiring rights of way over federal land, and also a statute would ordinarily not be regarded as dealing with the enacting sovereign's own rights and own rights in property. This is a statute that deals with non-federal property, with state-owned property in this case, or private property.
Your client wants this pipeline to be built. Why don't you just have a federal official join the action and then, advise the court that the federal government is proceeding along with PennEast?
I don't think that I think in order for the United States to become a party, there would have to be some statutory authorization for the United States to conduct the eminent domain proceeding. I suppose a federal attorney could attend and advise and participate in some sense, but that doesn't seem to be the defense being offered by the state. Congress.
Thank you, counsel. Justice Thomas.
Thank you, Mr. Chief Justice. Mr. Needler, do you agree with petitioner that they are somehow a limited purpose federal actor, or that they've been deputized by the U.S. to condemn property?
I think basically yes. I mean, various terminologies have been used. Cooley describes it that the person is a public agent. This court in Cherokee Nation said that a private person is an instrumentality of the government, delegate, and a lot of labels are used, but basically the Constitution authorizes Congress to vest the or allow a private party to exercise the right of eminent domain. So I think saying that the private party is deputized is a fair characterization, but I don't think anything turns on the particular label.
Do you need a clear statement in order to accomplish that, or do we just simply imply that? You do not need a clear statement. The clear statement issue comes in where the question is whether Congress has abrogated an existing immunity. In our view, and we agree with the petitioner on this, there is no immunity to abrogate to begin with. So the question is applying ordinary principles of statutory construction, whether the statute authorizes the private party to commence the eminent domain proceeding. And here we think it's clear that it does. Respondent acknowledges that the FERC could properly cite this pipeline across state lands, and the statutory provision here says that whenever a certificate is issued, the certificate holder can exercise the right of eminent domain if it can't acquire the property by agreement in order to complete the project, and that authorization has to apply to all the land over which the pipeline has issued. Otherwise, the pipeline couldn't be built. Thank you.
Justice Breyer?
Yes, thank you. If you were to lose this case, what would happen to the network of pipelines across the country now, at least those segments which were taken from states or on state land that were taken through eminent domain?
Well, those that, I assume those that were acquired by agreement or...
No, forget that. Those taken by eminent domain.
To the extent there are ones taken by eminent domain, I think the judgments in those cases would stand. Perhaps the states in those cases might try to have those judgments reconsidered, but I think they would.
Suppose that an owner of one of those segments, the state said, we do not want inspectors or repair people to come onto our property, which was taken by eminent domain, though improperly.
I think the eminent domain judgment would still stand. Now, there could be situations in which what the pipeline acquired was a time-limited easement, and so if that had to be renewed, even though the pipeline is now in place, if the state said, well, we don't want this pipeline anymore, and we're not going to renew your easement, that could be a problem. That would be a problem. So in that situation, the court's decision could have an impact on existing pipelines.
Thank you.
Justice Alito?
Do you agree that the condemnation actions here are really in rem proceedings that don't implicate sovereign immunity at all?
They are in rem. It is not our position that the mere fact that something is in rem means that it is not, that sovereign immunity principles don't apply at all. I mean, that's an important principle for the United States government, that a suit against the government's property is a suit against the United States. We've got Minnesota versus United States and United States versus Alabama for that proposition. But we do think that in the end, the nature of the proceeding as in rem, when coupled with the longstanding tradition of enabling private parties to exercise it, we think those things in combination do support the validity of it, because what's left after FERC has approved the pipeline route, it's a federally authorized taking. All that is at issue anymore is the amount of compensation to be paid to the state. It's not the sort of situation involved in Blatchford or other cases where it's a claim for money from the state based on state wrongdoing. So I think that the nature of it as an in rem procedure that is triggered by federal authorization, we do think that supports the position that there is no sovereign immunity.
All right, thank you.
Justice Sotomayor?
I'd like to address your jurisdictional argument. It does seem strange to require a state to initiate litigation in one court of appeals, the D.C., in order to invoke sovereign immunity in another, when it hasn't been sued yet. So there's no existing claim against it that it could raise the defense in. How does that make sense?
Well, the statutory question of PennEast's capacity to sue is not an immunity question. It is a question of whether they have the power under the certificate issued by FERC to execute that certificate, which is the way the court put it in the City of Tacoma case, to execute that specifically with respect to exercising the right of eminent domain against state property. That was the very question at issue in City of Tacoma, and the court held that had to be litigated, if at all, on direct review of the FERC's petition.
So isn't this, I mean, instead of requiring a suit in the D.C. Circuit to decide this issue, why couldn't PennEast have just raised this as, I guess, collateral estoppel? Because that's really its argument, isn't it? That the delegation to PennEast could have and wasn't challenged in the D.C. Circuit, so it's collateral estoppel?
Well, I
claim preclusion.
I guess it would be claim preclusion.
Yes, claim preclusion. I think you're right.
I think that, I mean, that would apply, but I think City of Tacoma and the statute are statutory strong forms of claim preclusion because they also require that the issue be raised before the agency. And in fact, FERC did address various questions about the right of eminent domain, but the state did not make this argument and didn't raise it on judicial review, and we think under City of Tacoma it can't be raised in the district court. But that doesn't mean that the actual immunity, 11th Amendment immunity question can't be raised, and that's properly before the court, and we think there is no such 11th Amendment immunity.
Thank you, counsel.
Justice Kagan?
Mr. Kneedler, suppose the federal government didn't like something about the way PennEast was conducting this litigation, whether it had to do with negotiating with New Jersey or with valuation decisions or anything else. If the U.S. didn't approve of something, could it do anything, and if so, what?
Well, we haven't addressed that. I suppose it's possible. I don't know what the FERC procedures would be, but it might be possible for the state to request suspension or stay of the certificate. I don't know if that would be something that FERC could do. It could be asked to do that. Perhaps some appeal to FERC to exercise some sort of persuasion in the conduct of this. I mean, after all, FERC does not have an interest in a pipeline behaving badly. But I don't think there's any basis for thinking that that's going to be true. These are ordinary.
I guess, Mr. Kneedler, my concern here is that, I mean, in several cases we've talked about the need for a suit against states to be conducted by politically responsible actors, federal lawyers, and whether there's not something that's really lost by giving this over to private parties who have their own interests separate and apart from what the government's might be.
Well, the critical decision with respect to these condemnation actions, whether the state's property will be taken, has been made by FERC, which is politically responsible. There's no question that FERC is responsible.
Right, but in the conduct of the suit, and we all know that the conduct of the suit can involve important questions.
Well, here it is a very narrow question in terms of the amount of compensation, and that's the sort of issue that courts decide all the time with a party on one side and in this case a state on the other side. But condemnation proceedings are handled in court all the time. And
thank you, Mr. Kneedler.
Justice Gorsuch?
So, Mr. Kneedler, I'd just like to return to the 11th Amendment itself, putting aside larger questions of structural or sovereign immunity. And I discussed with Mr. Clement, whether PennEast is a citizen of Delaware. That's one issue. And then the other is whether we have a suit in law and equity. And the in rem was proffered as a way to get around that. But I'm not sure how that happens when this court has said repeatedly, as far back as 1875 with Cole versus United States, that proceeding to take land and determine compensation is a proceeding in common law. Would seem to be a suit in law and equity, whatever else it is. So what's wrong with that? Why doesn't this fall within the plain text of the 11th Amendment itself?
Well, I think there is the argument that that PennEast is in its capacity as suing as an agent or however you want to describe it. Of the
I understand it's a delegate, an agent. We've got a lot of words. A deputy. But a deputy has a residence, and this deputy's residence is Delaware.
Right, and I accept that, and we're not saying that that the company is not a citizen of Delaware. Whether this is a suit against the state under the particular circumstances of this case is another question, given the in rem nature of it. But we think the basic point.
Well, but I mean, help me with that, because it is sued against the state at law or in equity, and this court has said a proceeding to take land and determine compensation is just such a thing.
It is a suit in law or equity. I mean, there's a further question of whether it is against the state, but because of the in rem nature. But our basic point, though, is that the 11th Amendment was meant to.
The state's the one entitled to compensation, right?
Yes.
Money will be provided to the state.
Right.
So how is it not a suit against the state at common law?
I think probably the better understanding is that it is a suit against the state, but I think the point is that this is a proceeding of a distinct character, and the 11th Amendment was simply meant to restore an immunity that had been taken away by the court, and that pre-existing immunity was one that structurally did not bar this sort of action by someone whom Congress has vested with eminent domain authority.
Thank you.
Justice Kavanaugh.
Thank you. I have no additional questions.
Justice Barrett.
Mr. Kneedler, I have a question just to follow up on one that Justice Gorsuch asked you. You said that you thought, when he was asking you about the 11th Amendment, that maybe the better way to think of this was that it was a suit against the state. And I've been trying to get my mind around what role this in rem issue plays in all this, and particularly because Federal Rule of Civil Procedure 71.1 required the state to be joined as a party, as the property owner. So if you say the better way to think of it is really as a suit against the state, you said you've accepted PennEast's argument about the in rem nature of the proceeding. How does 71.1 and the in rem nature of the proceeding and your concession to Justice Gorsuch bear on that?
Well, the 71.1 requires that the property owner be identified for purposes of getting notice. What the consequence of that is in terms of party status in the 11th Amendment, I think, is a different question. But again, our basic point is that this is not the sort of action to which the states were immune to begin with. And
no, I understand that, but I'm asking specifically, you said to Justice Gorsuch that the better way to think of this is that it's a party against the state. So I was asking how that bears on how we should think about this specifically as an in rem proceeding, because that's one of PennEast's arguments, of course, that sovereign immunity doesn't apply here. So is it in rem or is it more in personam?
I think it's frankly its character is more in rem. The state obviously has an interest in it, and it's a particular kind of in rem where the consequence is the payment of money to the state in exchange for its property. It's sort of a contractual exchange in that respect. So it's not the sort of proceeding that the 11th Amendment, as this court has described, is most concerned about, which is a suit for damages against the state, where the state might be a wrongdoer, and here where the federal government itself has decided that the particular land should be taken. The only question is the compensation. So it's in that respect we think that the in rem character of the suit matters, and also plays into or coincides with the fact that the states were not immune from this sort of action by the federal government or its agent.
Thank you, Mr. Kneedler.
A minute to wrap up, Mr. Kneedler.
Yes, I'd like to underscore the importance of the immovable property exception in the city of Chattanooga here, because in the city of Chattanooga, the city, a delegate of Tennessee, which was the superior sovereign in that case, was permitted to sue Georgia, and there was no immunity in that situation. What we had, and that's the same as the immovable property exception that the court discussed in the permanent mission of India. What we have here is the equivalent in the supremacy clause, where the superior sovereign comes from the fact that the United States has to have complete authority with respect to the exercise of eminent domain, and the state is not immune from an action by the United States through its agent for these purposes with respect to property within the territory of the United States. That's the relevant situation. And Justice Bradley's decision in Stockton is also instructive on this point, which was quoted in the Cherokee Nation case extensively, that Congress can utilize private entities to carry out public functions. It's more efficient. The pipeline here is the entity that is going to construct to profit from it, and to require the United States to become involved in a suit like this in aid of something that has already been federally approved would not promote the values of sovereign immunity.
Thank you, counsel. General Feigenbaum.
Mr. Chief Justice, and may it please the court. PennEast cannot hail New Jersey into federal court for two independent reasons. First, the 11th Amendment bars this suit. The United States has a necessary and proper power to file condemnation suits against the states to effectuate all its other enumerated powers. But private companies like PennEast do not, because as Alden held, private party suits against the states are never proper. State consent to suit by the United States was not consent to suit by those the U.S. might select, and there are important differences between lawsuits by responsible and politically accountable sovereigns and those by private parties. The only way to justify this private suit against the states is to provide evidence of founding-era consent. But condemnation lawsuits against non-consenting states were unheard of at the framing. Second, even where Congress can subject a state to private suit, its choice must be explicit in the statute. Congress would not subject the states to private suit without doing so clearly, and this approach advances fundamental protections for fellow sovereigns. That rule also dictates the result here, because the NGA is silent as to the states. That leaves PennEast's complaint about the practical consequences, but those concerns have not been borne out in reality. Other industries expressly lack the power to file condemnation suits against non-consenting states in federal court. Yet oil pipelines and electric transmission, like other infrastructure projects, proceed apace, and New Jersey itself has continued to grant rights of way to other natural gas projects even after the decision below. In any event, this is the rare constitutional case in which the parade of horribles can be easily fixed by Congress, and it provides no basis for eliminating the state's immunity to private suit. I welcome this court's questions.
Counsel, you talked near the end there about the practical problems. Does the state oppose the pipeline?
The state has opposed the pipeline in a separate D.C. Circuit proceeding, although that's distinct from the challenge we've raised below in this case.
Well, that seems to present a significant practical problem.
So I don't think it does. I don't think that the sort of landowner veto concern that PennEast raises holds up for two reasons. The first is that other industries expressly lack the power to file these sorts of actions. And as I noted, oil pipelines proceed, electric transmission proceed, and so on.
Well, I don't know. Maybe those did or did not cross state property, or maybe the state didn't oppose those, but you oppose this one, and it crosses state property. That seems to be a pretty practical problem.
So there's no reason to think that other industries have to cross state land any more frequently than the natural gas industry does. And we've included in our briefing examples from other states and in the New Jersey Conservation Foundation briefing indicating that those other industries do cross state land all the time.
Well, but your client opposes this pipeline. So if they say no, it doesn't go forward.
So to the degree that this court has concerns about that, this is the rare constitutional case in which all of the consequences can be remedied by Congress. And it requires a sort of double speculation on PennEast's part. PennEast is speculating that states will impermissibly try to wield veto powers when there's no evidence from any industry to support that view, and New Jersey itself has granted rights of way to other natural gas pipelines even after the decision below. And then it's again speculating that Congress won't step in, even though Congress has consistently passed new statutes to address problems that industries confront in the condemnation context. I don't think that sort of double speculation is enough to justify eliminating the state's sort of historic immunity to private suit without evidence of founding-era consent.
No, I'm not suggesting that it's enough to eliminate the immunity, but it does strike me as a concern why supporting Mr. Clement and Mr. Needler's argument that you're dealing here with the federal delegee, and what the state is doing is, in other words, the federal government in this scenario does become a junior varsity sovereign. The state is blocking the NGA certificate issued by the federal sovereign. Do you have a response to that?
Absolutely. I don't think the United States is becoming a junior varsity sovereign. I do think that the United States still has the complete power of eminent domain. I just don't think that resolves this case. The United States has all kinds of complete or superior powers, like the power to recover federal dollars or the power to set patents and punish infringers. But it can't subject the states to private party suit as a means of effectuating that power. And that's, I think, especially true in condemnation. Eminent domain itself is an implied power, meaning it's a necessary and proper way to accomplish other enumerated powers, like the Commerce Clause. But we know that when states are acting under the Commerce Clause, private suits, or when Congress is acting, private suits can't be implied against the states, because they aren't necessary and proper. And the way to square that is easy. The United States can condemn sovereign land when it takes responsibility and ownership of the suit, but it can't select a private party to do so over a state's objection, exactly as Justice Scalia put it in Blatchford.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, what difference would it make if the U.S. sanctioned the proceedings, the condemnation proceedings or efforts that PennEast is now making?
I think it would make both dignitary and practical differences for the state. So obviously, as to the dignitary harms, I don't think we should forget that PennEast is trying to directly subject a state to the jurisdiction of a federal court over its objection, which is the sort of offense to the dignity of co-equal sovereigns that is exactly what the framers were guarding.
But in the end, what does that all mean?
So in practical sense, our concern in this case is that a private plaintiff is the one that gets to decide whether to take state land it might never need, while the pipeline and the route remain subject to so much change, which is something we think a more responsible and politically accountable sovereign would be less likely to do. So at pages 168, 175, and 235 of the record, there's considerable evidence that PennEast's actual route might change, and FERC itself instructed the company to consider a change of the final 2 miles of the route as part of the future permitting stage and as the process unfolds. But PennEast went and sought eminent domain along the entire original route, which is something that we think the United States would be less likely to do relative to our sovereign land when all of this process is still ongoing.
Well, you've said a number of times that it's your sovereign land. How much of this land do you have a possessory interest in?
Of the 49 parcels that we're talking about, we have 9 in fee, and 40 we have other sorts of property interests to which we hold title.
What kind of property interests?
It depends. Sometimes agricultural easements, development easements, and the like. They're not all the same kind across the 40.
So let me ask you just an opportunity. I'd like you to respond to the petitioner and to some extent the U.S.'s argument that because this is an in rem action, it doesn't implicate sovereign immunity at all.
I appreciate the opportunity, Justice Thomas. As I think the United States admitted, there are a number of cases from this court that suggest just the opposite, that parcels to which the United States or a state have an interest in are lawsuits against the state or the United States itself. And that makes sense. The United States is the one that actually has to litigate this case. The state is the one that has to. The state is the one that's going to lose its parcels where a private plaintiff is deciding when that happens. And the state is the one that has to participate in an adversarial compensation trial. The immovable property doctrine on which petitioner and the United States are relying was about something else entirely. It wasn't about a general in rem exception or an in rem exception that would extend to New Jersey's land that we own within our borders. It was about property that we own outside of our borders where we, quote, assume the character of a private landowner and don't function as a sovereign. This court said that in Chattanooga and Schooner Exchange and in the separate opinions in Upper Skagit. And the reason that matters is that the immovable property doctrine would also open us up to private suits, as this court may remember from the Upper Skagit case and the Lundgren's quiet title suit against a tribe. Immovable property isn't just about eminent domain, but is about property suits generally, and everyone agrees New Jersey's not open to that sort of private property suit for land we own within our borders.
Finally, I'd like you to take an opportunity to comment specifically on the delegation, the U.S.'s delegation of its sovereign exemption.
So I don't think anything changes because PennEast is relying on delegated or deputized authority. As Alden and Blatchford explain, the United States can always sue the states, and when it does so, it takes political responsibility for the lawsuit itself, controls the decisions in the lawsuit, and doesn't offend our sovereignty. But a private lawsuit is different because it leads to
what would it take for this to happen, though? Can the U.S. Even delegate its exemption?
We don't think so, no, because as Justice Scalia put it, consent to suit by the United States is not consent to suit by those who the U.S. might select. So select or delegate or deputize, whatever word we want to use, I don't think this sort of workaround from the usual abrogation rules can really exist in our constitutional scheme.
Okay, and on what do you base that?
I think we base that on Alden and Blatchford and the lack of any evidence at the founding or in any time since that there's an understanding that simply because the U.S. can bring suit that it can delegate or deputize to someone the ability to bring that same lawsuit. It would really blow a hole in the way this court has always understood sovereign immunity.
Thank you.
Justice Breyer?
Thank you. Go back for a minute to the late 1940s, early 1950s. Most of the natural gas was in the Permian Basin, in Oklahoma and in Texas. And they were on the verge of or had built pipelines to carry that natural gas to California, San Diego, El Paso natural gas, or up to Pennsylvania, over to Illinois, up to Massachusetts. A lot of the states, not a lot, but some, were objecting in a whole variety of complex ways. And so Congress passed the Natural Gas Act. Now, they couldn't have built the pipelines unless they had this power, I think. I'm not certain of that, but I don't see how they could have, because they need. Go look at the map on the map of waterways in which Pennsylvania claims an interest in the Marcellus Shale Coalition. States own waterbeds. They own all kinds of obstacles. But this was passed to build a pipeline. How could they have done it? I don't see it. And having known a little bit about that, since you need the federal power or a government power for a private person to use eminent domain for anything against a private land or by a state, I don't understand how any reasonable person would have delegated any eminent domain power to the Natural Gas Act, which was for interstate pipelines, without including the power to proceed against the state. Am I right about that? And if I am right, and therefore it is clearly in this statute, why in heaven's name can't the Federal Power Commission then, or FERC now, have done the same thing? And if they could have done the same thing under law of Congress, why can't they hire somebody? Just as Mississippi hires private prosecutors sometimes in criminal cases, or there are dozens of examples where private persons are delegated under supervision, and here the supervision is close, to go and do something that the public can do, like bring a criminal case, et cetera, et cetera. You see the thrust of my arguments. Very historical. But that's been the understanding for the last 80 years.
So I think I have three responses to that, Your Honor, if I might. The first is that I think the premise of that question relies on the same misconception that's at the heart of PennEast's brief, which is a speculation about the way that states behave. We know from other industries, including the interstate oil pipeline industry.
No, sorry. The thrust of my question, why I kept saying historical, is I do know how states behaved in the late 40s and early 50s. And from reading the newspapers, I know that natural gas is a subject of a big argument politically in a lot of states, some thinking it's great for the environment, and others thinking it doesn't go far enough, it has risks. Those are the two things I know, not speculation.
So I appreciate that, Your Honor. I think those same things could be said about the oil industry, but we don't see the concerns being raised here, even though they don't have any sort of federal eminent domain authority that anyone would purport allows them to hail non-consenting state into court, and yet they are built anyway. There was
Are they building now big oil pipelines like down from Canada to New Orleans?
Sure, but there hasn't been any evidence that a problem in that process has been sovereign immunity, even though everyone agrees that there's no ability to raise federal eminent domain claims against non-consenting states in that context. And I think what that shows is that there's plenty of reasons why pipelines might not get built, having nothing to do with sovereign immunity, but that uncertainty does exist in the industry, which is one of the reasons why we were so nervous about condemnations even before the permitting process had finished. But to take your point on the statutory question for a moment, it's also notable that other times that Congress has spoken to the issue, it has understood that sometimes it wanted the statutes to include state land, and sometimes it didn't, and sometimes it excluded them, which, if it was true that every industry going through state lands was going to need this power, well, then it would be very strange to see those exclusions. Congress was silent here, and it doesn't give us much to work with.
Thank you.
Justice Alito?
Counsel, sometimes form is dispositive, and you may, in the end, have a winning formal argument. But what I want to look into is whether you have anything more than a purely formal argument. Now, you argue that things might have worked out better for you if FERC, as opposed to PennEast, were conducting the proceeding because the federal government is obligated to negotiate in bad faith, and there's the issue of timing. But I take it your constitutional argument would be, in the end, exactly the same if none of those features appeared in the statute that's involved here. Would it not?
So I think formally it would, although I would agree with you that functionally and what's at stake, we'd be talking about something different.
So really, it's just about the form. It's the fact that it's PennEast and it's not FERC.
So I don't think that's right. It's not just about the form for New Jersey. And you're hypothetically, of course, took out the substantive concerns that we were afraid of. But in this case, in the case we're actually facing, we do have substantive concerns about this litigation and the calls that PennEast, rather than the United States, are making. We think it's
I understand that. But if PennEast were required to negotiate in good faith, if all of this was, the timing was they couldn't bring the condemnation action until the route had been finalized so that FERC had approved the very route in question and knew that it was going over state land and presumably wanted the land condemned, and all that was left to be done was to file the condemnation action, ascertain the value of the property, you would have exactly the same constitutional objection.
As a formal matter, yes, because it's still a lawsuit directly filed against the state by a private party, which we think is exactly what the framers thought would be an offense to the fundamental dignity of sovereigns who can't be held into court without their consent.
Is New Jersey's dignity really, in any kind of practical terms, compromised to a greater degree based on the caption of the lawsuit?
We think yes, because if it were otherwise, then all manner of this court's cases would have to come out, I think, differently. In Alden, for example, the court was facing a private suit that everyone agreed the United States could have brought instead, but it was the fact the private party was bringing it instead of the United States that created an offense, even if it was sort of just the state as employer, just like New Jersey as landowner. The fact is the offense to a state's dignity is the private party lawsuit, and that's the through line of all of this court's cases in sovereign immunity.
No, I understand that, but it is a purely formal argument. Okay, thank you.
Justice Sotomayor?
Counsel, just to be clear, other than your argument that PennEast didn't negotiate in good faith, contrary to the finding of the court below, all of the other arguments you mentioned throughout your presentation to Justice Alito and others are about issues that you litigated in the D.C. courts, didn't you?
No, Your Honor, I don't.
Well, you litigated about whether they should wait, and the government responded, not in the way you liked, but it did. What else did you not have an opportunity to or didn't litigate in that case?
So two things, Your Honor. First, the adversarial compensation trial to which we're going to be subject if PennEast prevails on this posture in this case is a contested compensation trial over the value of sovereign land where a company can fight tooth and nail to keep away from us the money to which we think we're entitled. So none of that is ever going to come up.
Well, that's true, but that would be true whether it was the government or you.
That's right.
And once the decision is made that land's necessary for a public service, that you're subject to anyway. What was the second thing, counsel?
The second thing was that we did raise issues around the timing, but FERC didn't just say, we disagree with you on the timing, we want it to go forward. At page 239 and 240 of the record, FERC said the timing is something to be worked out in the district court with the private party and New Jersey. So it was sort of washing its hands clean, exactly as we say shouldn't be able to be done by a responsible sovereign.
Well, you had the opportunity to litigate that, and you lost, correct?
So we raised it, but they didn't say you have the opportunity and you lose. They said go raise it somewhere else.
Well,
so we did.
But you could have appealed that. Going to Justice Alito's question about formalistic, it seems to me that history is very important to me, and I think that was the point of Justice Breyer's position, which is that for at least 150 years, some states, not all, have been delegating to private parties their power, the power of eminent domain. And the federal government and other agencies has done it. And no one has raised this argument because, if one accepts Mr. Clement's argument, there was no sense that there was a sovereign immunity to eminent domain, the exercise of eminent domain by the federal government or by a state against its own citizens. And hence, who they delegate that power to, unlike the other cases that we've addressed this issue, or this issue has been around, that only the state can do, that at least in this narrow field, the in rem nature of this proceeding has gone differently in history than in the normal cases. How do you respond to that?
I don't think that's what the history shows for a couple of reasons. First, the history of the fact that states haven't asserted this argument before I don't think is all that telling, because the Natural Gas Act is Commerce Clause legislation, and it wasn't crystal clear until 1996 in Seminole Tribe that Congress lacked the authority to subject states to private suit under that power. Since that time, a couple of states have raised this. Texas raised it in 2017, Connecticut raised it in 2003, and we know from 1992 legislative materials that New York did even earlier. But more importantly, I think it makes sense that this comes up infrequently, because PennEast is, again, wrong about the way that states behave. Even where states clearly have the authority to withhold consent, we frequently allow for rights of way, which is why this hasn't been a problem for other industries, and why New Jersey itself granted multiple rights of way to pending natural gas pipeline projects, even after the decision below. But finally, as FMC put it, modern practice can't overcome the lack of founding-era consent. And so in addition to being not that compelling, I think in the unique context of sovereign immunity itself, the sort of practice to which PennEast and the Solicitor General's office are pointing just isn't that relevant, and certainly can't overcome the very clear historical evidence from the founding that no one would have contemplated private condemnation suits against non-consenting states.
Thank you, Kevin.
Justice Kagan?
Mr. Feigenbaum, does this suit have to be labeled United States versus New Jersey? And what if there was meaningful supervision by the federal government over PennEast's conduct? Would that be enough?
So you're right, Your Honor. This suit does not have to be named as United States versus New Jersey. It is PennEast versus New Jersey, as the court's caption suggests, and there's no naming convention that would have it be the United States in this case.
No. I meant, could the U.S. delegate the power to PennEast, in your view, but keep some sort of supervisory capacity over the suit? Would that satisfy the 11th Amendment?
So I think the answer in that case is probably the same one this court gave in Stevens, which is I doubt it. But what would make that case hard makes this one easy. If the United States actually contained or oversaw and directly supervised the litigation itself in some meaningful way, it would look a lot more like the kind of control that led to the circuit split over key TAMs, and therefore you could see a different result with the U.S. being the real party in interest. But none of that exists here.
You spoke to Justice Alito about the state's dignitary interest and said that this has been a consistent through line in our sovereign immunity cases. Most of those cases in the modern era have had powerful dissents attached to them, and those dissents have basically said, what are you talking about this dignitary interest? What dignitary interest does a state have in being, why is it any less or greater if a private party or the United States is involved? So could you explain that to me? Like, what is the supposed dignitary interest?
The dignitary interest, which I think comes from the founding era documents, is that it was always understood for any sovereign that you could not be held into court without your consent. That was sort of black letter, pre-founding understanding. And so if it was true that states really did retain the true sovereignty that everyone had promised them when they joined the Union, then they would, as a matter of actually being co-equal sovereigns treated with that sovereignty, they would have the ability to withhold consent as well. Now, it's not true vis-a-vis other states in the United States because, as we know in international law as well, it's always looked different for sovereign-on-sovereign sort of litigation, in part because of their responsibility and control, and in part because that's never been understood to offend sovereignty. But if you allow private suits forward against the states when they don't consent to them, it suggests that states really aren't the kind of sovereigns that they were promised and that the founders understood them to be.
If you go back to this question of whether there was founding era consent, I think what PennEast would say is that you knew you were consenting to suits against the federal government, and you knew that governments routinely used delegations to effectuate eminent domain suits. So you put those two things together. Why didn't you consent to suits of exactly this kind?
So I don't think you can just put those two things together, because that syllogism would cause all sorts of problems. Imagine in, say, a normal property context or in the patent context. You know that the United States would be able to have a patent power and file patent lawsuits against infringing states if it saw fit. You know that the United States would be able to empower private patent holders to sue private patent infringers. So why can't private patent holders sue state infringers? Everyone understands that that last step in the syllogism doesn't follow from the others, because what we're actually looking for in sovereign immunity cases is state understanding and consent to the idea that they could be held into court, not if a federal power existed, but if a private party could use them against their consent.
Thank you, Mr. Feigenbaum.
Justice Gorsuch?
I'd like to return to the question of whether this is a suit against the state. In some respects, it seems pretty hard to dispute that the state is named as a party, and under Rule 71.1, the complaint had to file suit against both the property and at least one of the property owners. And, of course, there's going to be compensation due to the state, which would seem to be more in personam than in rem. But there's also a long strand of thinking about condemnation proceedings as in rem, as the notes to the rule make clear. And, of course, we've heard some argument today that that's the better way to conceive of these kinds of suits. Can you speak to that a little further?
Absolutely, Your Honor. So I don't think there's any sort of general in rem exception to sovereign immunity. As this court has recognized, a suit directly against a sovereign's property is a lawsuit directly against the state, both formally and functionally. And that's why the Rule 71...
What's your best common law authority for that?
So I think the best authority that we have actually could come from the immovable property doctrine, which existed specifically to draw a contrast to the land that states owned within their borders. So the idea of the immovable property doctrine being cited by both PennEast and the United States was that states, when they owned property outside of their borders and got sued, that wasn't...
I'm sorry to cut you off there, but I understand that. I remember Upper Skagit. I may be the only person who does, but I do. Having gotten saddled with that one, it was a delightful assignment. But that has to do with property outside the state. What about inside the state?
Well, and I think it's Cole, and I think it's Minnesota versus United States explaining that these are suits at law, and that a lawsuit against the United States or a lawsuit against land in which the United States has an interest is a lawsuit against the United States. That's why states can't condemn, for example, tribal land where the United States holds a fee interest. And we can't condemn that land simply by naming the land and choosing not to name the United States, because that is in both form and function a lawsuit against the United States we don't have the ability to bring. It was entirely different in cases like admiralty and bankruptcy, which are the only exceptions where this court has allowed in rem to move forward in that way, based on really unique founding era history that's not present here. In admiralty, it was that admiralty suits were not understood to be law or equity and therefore didn't trigger the application of the 11th Amendment clause, as we know from Justice Story. And then in Hood, it was specifically about the uniqueness of the bankruptcy clause and the fact that jurisdiction is over the debtor's property, not the state's property, and so it isn't formally seeking any affirmative relief from the state. That's Hood at page 450. There's no historical evidence and no example that anyone can point to that would allow for a direct lawsuit against a state's land as somehow distinct from a direct lawsuit against a state.
Thank you.
Justice Kavanaugh?
Thank you, and welcome, General. I just want to ask one question. In your brief, you respond to PennEast's arguments about what will happen if you were to prevail in this case. And you respond by saying, well, of course, Congress could take action. And then you say, this is page 45, but even absent congressional action, PennEast is hardly without options. And then I want to focus on your first one there. First, while the United States disclaims authority under the NGA to condemn property, the lower courts have had no occasion to consider this question, and this issue deserves greater exploration. So, is that a real thing or not, what you're offering there?
So below before the Third Circuit, and you can find this, I think, most clearly at pages 20 to 22 of our reply brief, we articulated a theory in which the United States might have an implied power under the structure of the NGA to itself step in, essentially on the theory like the Third Circuit suggested, that it's strange to think of FERC being able to grant private parties the ability to file these suits and not retain that power itself. Since that time, the United States itself has come in at PennEast urging to say we actually don't have that authority. They obviously say it in the gray brief, but they said it in a declaratory order as well. So I don't want to pull this court's leg and say they're definitely going to move forward with that. We had thought it was a workable theory worthy of exploration, but the U.S. continues to disclaim it.
Thank you.
Justice Barrett?
Is there any space for an inverse condemnation proceeding in this scheme, where the FERC certificate could issue and PennEast could just take over the property, and then you could pursue an inverse condemnation proceeding?
I don't think so, Your Honor, because as this court held recently in Nick, a taking without compensation violates the self-executing Fifth Amendment at the time of the taking. And so, PennEast basically says this lawsuit is to remedy a Fifth Amendment problem, but we think it's a false choice between the Fifth Amendment and the 11th Amendment, because the U.S. could bring this lawsuit in a way that is absolutely coherent with the Fifth Amendment and with the 11th Amendment simultaneously.
Let me ask you about the Fifth Amendment and how it might relate to the immovable property doctrine. Do you agree that all of your land or your property is private property for Fifth Amendment purposes, which is what permits you to have a takings claim in the first place?
Yes, we agree with the court that state land, sovereign land, can be condemned, and we have the same rights under the Takings Clause. Okay, so if it's private property for purposes of the Fifth Amendment, why shouldn't we treat it as private property for purposes of state sovereign immunity as well? So I think the court didn't say it was actually private, but just that it was sort of incomprehensible under the Takings Clause that you would be able to have condemnations of sovereign land to which the sovereign was even less entitled to relief than for a private party, and that's how they reasoned it. There's no sort of reasoning here that I think would justify a private lawsuit against a state as somehow necessary and proper from that reading of the Takings Clause.
Well, doesn't it bear on the immovable property argument that PennEast is making, that, if a state has property, if Georgia has property within the borders of Tennessee, the immovable property, Georgia can be sued because it's treated basically as the equivalent of a private landowner because it's not land within its sovereign territory. But if the Fifth Amendment treats this as private property for those purposes, doesn't that strengthen PennEast's argument about the immovable property doctrine?
I don't think so, because the reason that the property was private property outside of our borders was specifically because a state can't be a sovereign in another state's territory. So Switzerland can't be sovereign in the United States. We can't be sovereign in Georgia or in Pennsylvania. And the consequence of that, and why I think the theory proves far too much, is that it opens the state up to private property suits like the Lundgren's quiet title suit in Upper Skagit. So suggesting that a movable property doctrine has a role to play here goes well beyond eminent domain, because it is not a theory that is actually linked at all to the teachings of the Takings Clause.
I want to go back to something you said to Justice Thomas about possessory and or the kinds of property interests at stake. You told Justice Thomas that the state had 9 possessory property interests. Is that right?
That's right. So this action has 42, and then there are 7 that are state. So when you combine out of those 49, we get to 9 possessory interests.
Should we treat that as significant? I mean, deep sea research, we treated that line as mattering. Should we treat that line as mattering here, a distinction between possessory and non-possessory interests for sovereign immunity purposes?
With one important caveat, which is that everyone has always understood for intangible property interests, which is what an easement is, there's no such thing as sort of actual possession in that way. And so the restatements define possession for intangible interests as having title, and we have title to all of the easement interests that we have in this case. So even drawing that line would sweep in all of New Jersey's interest in this particular dispute.
Okay, last question. In your view, would there be anything to stop you or any other state from waiting until FERC approves the pipeline's route and then purchasing a property interest in land within the pipeline's path and then asserting state sovereign immunity?
Anything to formally stop? No, but there's no evidence any state has ever done this.
No. I just asked if there's anything formally to stop.
No.
Thank you.
A minute to wrap up, counsel.
Thank you, Mr. Chief Justice. A ruling for PennEast would be unprecedented because it would allow a private party to subject the states to the indignity of a federal suit without their consent, because it would allow a private company, rather than a responsible and accountable sovereign, to control the litigation, and because it would allow PennEast to decide whether to risk needless condemnations of state land while the pipeline en route remains subject to so much challenge and change, and to decide how much sovereign land is worth in an adversarial compensation trial. But PennEast lacks the evidence to justify that drastic step. When it comes to the Constitution, PennEast provides no founding-era evidence that states contemplated private condemnation suits, and when it comes to the NGA, PennEast identifies nothing in the text to show that Congress explicitly endorsed private suits against them. PennEast's condemnation carve-out thus relies on the very evidence this Court has rejected so many times before: silence in the Constitution, silence at the founding, and silence in the text of the statute. Thank you.
Thank you, counsel. Rebuttal, Mr. Clement.
Thank you, Mr. Chief Justice, and may it please the Court, I'd just like to make 3 basic points in rebuttal. First, on the delegation or deputization point, I don't think it's right for the state to suggest that this is just like Blatchford or this is just like Stevens. This is a power that's constrained completely by the federal government. PennEast cannot get into court at all unless it is given a certificate for particular properties. FERC continues to have the authority to oversee the actions and could modify the certificate, and the authority that FERC asserts for that, and this is directly responsive to Justice Kagan's question, is 15 U.S.C. 717-0. But even beyond that, eminent domain is not like the ability to have a delegated chance to bring a damages action against the state. It's an inherently government function. The state's treasury will be augmented, and for purposes of the action, PennEast is a federal actor for Fifth Amendment purposes, so all we're asking is to extend this parallel logic to the 11th Amendment. Second, I want to talk about the in rem and form versus substance. As Justice Alito's colloquy showed, the position of New Jersey here is entirely a formal argument, but if we're going to go on form, and I'm going to talk about substance in a minute, but if we're going to go on form, the form of an in rem action is an action against the land. Or if you want a historical framing era source, look at Bushrod Washington's decision in United States against Bright, where he talks about an in rem action being an action against the world. What you're doing is you're settling the rights of the land, and that's why in rem actions are fundamentally different. They are not in personam action. A foreign owner of land can't block eminent domain or other in rem proceedings just by not showing up because the territorial process of the court doesn't reach them. And importantly, Rule 71.1 does say that the PennEast is supposed to name the state as a property owner, but this court in Hood specifically said that provisions of the rules don't change the fundamental form of the action. It was in rem there, it is in rem here, and it is a fortiori because this is an in rem action that can only augment the state treasury. And as to dignity interest, there's not even an allegation of wrongdoing here. So lastly, let me just close by inserting the point that to insert a sovereign immunity defense to the eminent domain authority is to lose the forest for the tree. Sovereign immunity is a stranger in a strange land when it comes to an assertion of eminent domain. And the New Jersey concedes the validity of the federal exercise of eminent domain here. They just want to insist on how it's exercised. And that is not an authority that an inferior sovereign gets under any authority, especially when they're wielding that authority as a property owner to veto a federal infrastructure project. Thank you, Your Honors.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Tuesday next at 10 o'clock.